Maybe filing to make a mention that. So it appeals and the order of the honorable single judge notes where the practitioners they are the diploma degree holders of the engineering university. For the post of selection of the diploma engineers, I have participated, but in fact,
read the pre Phrase admission.
Language in general custody more than it is applied language in general custody more than 8 years above. So for applicant religion on bail.
It mentioned before the assigned bench. Criminal appeals.
Chief and honorable Discourt.
This is the assigned bench. Our assigned bench. Oh, for criminal appeals. I was for the death reference and government criminal appeals. Justice is for the criminal appeals. I think.
I don't think so.
Yes, case of what number 5. What number 5?
Yes.
Go before that.
Attend the mention mail. It is a eviction matter mail. It was in the list mail, but it was not taken.
Make a mention my love. But this is 31227. It is actually a single instance. It was listed on 30th January 2025 before Honorable Justice S.K. Panigirai. But Justice Panigirai directed this matter to be listed before any other bench after seeking permission from Honorable.
That is the administrative side matter, so that will be placed. It will go to some other bench.
My predicament is
No difficulty. It has already been. I do not keep any file pending. The moment it comes, immediately. Don't worry.
Okay.
Yes.
Item number 49. The matter is they are trying to for amicable settlement. So 1 week will be made. 1 week after, my friend is online, Mr. P.C. Acharya.
Yes, my lord. There is a
Compromise.
I am in VC, my lord.
Yes.
There is a talk of compromise, my lord. 1 week after, my lord.
All it leads to 9th May. Spread by both.
Pardon, my lord. Item number 45. I am for the petitioner, my lord. And the Senior Council and my interest in the Senior Council will agree the matter. But in the day before yesterday, the listener had expired. That is why
Other side is present.
Sorry?
Other side is present.
I am for the appointment number.
There is no in 24 my lord.
Based on 14th May. Spread by Mr. Mahapadra for the petition.
Okay. Item 5 minutes. In that case, Mr. Mahanti has been engaged with Senior Mr. Mahanti Malad. He is not well. You'll also next week.
List on 29th April, as spread by Mr. Mahapadra. Council for the applicant petition.
Inform the other side. Other side has to be.
This is the first. Nobody has said. Okay. Asking for next week, 15, 16, 17.
All right, 16.
16. Obliged.
Following to mention out of list my lord, I have filed an CMAPL for restoration of a rate, but the matter is pending for fresh admission and not being listed since past 7 months. So it's a request. It may be.
What do you want? It has been dismissed for default.
Yes, previously it was dismissed for default.
Restored?
No, my lord. A CMA
Restoration.
No. Yes.
Number 1.
Message your lordship.
So if you pardon your lordship, they're on their way one passable, your lordship. The DCP is also a UC, your lordship. There's somewhere in the building downstairs, it's just something. One passable.
It's possible for 5 minutes.
Chess admission item number 2.
My lords, in this matter, Mr. Gyan Lok Mohanty, standing counsel, will be appearing in this
You
matter.
cannot seek adjournment in every case. Yesterday in your name, today you are taking others' name.
My lords, this matter is not marked to me, my lords. It might come tomorrow, my lords.
I find there is a difficulty also. I find from the list. I was talking to other side, Partha Satyanayake is appearing. He is now the government counsel. He cannot argue.
Yes.
It's on 24th May. 24th April.
Right.
I prayed on behalf of the state petitioner. He said us.
Item number 3.
Please, Your Lord. Intra-court appeal. Subject matter is a no confidence motion under the Odisha Gram Panchayat. But here, the short point is that whether the requisites of section 24 has been complied. Second specific ground that section 24(2)(a) of the Odisha Gram Panchayat Act has not been followed at all. In fact, for I benefit my lord, let me apprise your lordship
Yes.
that to convey a meeting of no confidence motion, it is to be done by the sub-divisional officer, my lord. 1/3 of the ward members, they will propose a resolution, pass the same for the SDO along with requisition to be placed in a specially conveyed meeting for seeking confidence or to resolve upon the no confidence motion. Now here what has happened?
You are a writ petitioner.
Yes, your lordship.
You were the writ petitioner.
Yes, madam.
The order is passed on your consent. You have made certain submission at the last paragraph, paragraph 10 of the impugned judgment. And if it is passed on your, then what can be done? Can you challenge it? Look at paragraph 10.
Madam.
So, what do you say? Accordingly, it is ordered because your submission was accepted and ordered.
So far as there are two
If
legal
you
challenge before the
why you have not? If you have not said those, then you will have to approach the same judge and say that I did not want that. You have said that this juncture submits that if the court is not inclined to intervene with the motion to be held on such and such, then it should be directed to be subject to the result of the decision by the opposite party. Number 2, with regard to the disqualification pending against some of the members who are the signatories of the resolution. However, considering the law such and such, response received such and such, of the view, the motion to take place as such, the cause of action would remain later to be disqualified. Same thing. What you said. The court has accepted that. So once your submission is accepted, how can you be said to be a aggrieved person?
Subject to your lordship's appreciation, madam. There are two limb of attack so far as
I understand.
the first one is that it violates 24(2)(a). The other one we foregone because that is the standing law.
But that was not there. If you say that the one portion is omitted, then you'll have to approach the same judge.
Would your lordship will kind enough to allow me further chance to address on this? Keeping your lordship's question, I have to answer. Any day. But I because it could not have been segregated in this manner while giving consent.
But that is what is there. And if you say that the consent was not in that sense, and the consent was only in relation to one of the points, then we'll have to approach the same judge.
Would your lordship allow me 1 or 2 days so that I can? I think I can.
Bank of Bihar case.
Madam.
Of the Supreme Court.
The things have been done.
So how can you now file an appeal? On his prayer, it's what is supposed to happen.
If the paragraph 9 is read, then.
But you ought to have that it was a concession so far as this point is concerned. There was no concession on the other point. I wanted that decision to come.
This is the petitioner has already. Lordship may give 1 or 2 days.
You were the counsel.
No. I cannot attribute or say. In fact,
your counterpart there in the single bench, yes, said so.
I take the responsibility.
Yeah.
Whosoever he may.
is my paternity.
Are you serious with the appeal? Now
Madam.
after this,
Pardon, my lord.
are you serious with the appeal? Because
Yes,
it has
Lord.
to be.
Just 2 days time so that I can try my luck to impress your lordship. At least with these
Luck.
I can.
It's not a luck. It's the law which
It's
prevails.
my effort. I withdraw it. Further effort. Such a concession ought not to have been.
Just on 15th April. As prayed by Mr. Raj and counsel for the petition to satisfy on the concession rendered on behalf of the writ petitioner, paper land and single judge, as per para 10 of the impugned judgment. To be thus and proper side.
Item number 4.
Place is remand. Last the delivered content of the state also appeal matter. In this case, this is intra-court appeal matter. In this case, the appellant challenged the order of the honorable single judge, wherein the writ petition is partly allowed by converting the punishment dismissal to compulsory retirement. So
You wanted that everything should go. You are made scot-free.
But there is a
Two impositions were there, dismissal and I think the pay scale was reduced. What? What was reduced?
actually converted to compulsory and the benefit should be given in compulsory retirement.
That is what the court has said,
Yes,
that at
yes.
least you will get all the benefits.
Yes.
Terminal will really foreclose all the retirement benefits and the other benefits.
Yes.
The single bench says that it is a compulsory retirement.
Yes.
You will get all the benefits.
But the court will surprise that the allegation were true minor. The respondent discussed the loan amount of 3 lakh
What is your
something.
ground
Lots.
to challenge the order of the land and single judge? What is the ground?
Ground that minor. The
He is a writ
yes, he has sanctioned the loan in favor of the family members. The respondent
What
lost.
do you want? To be exonerated from all the charges? And to be reinstated in service?
No,
What do you want?
dismissal is there now. The allegation is
Dismissal has been converted into a compulsory
compulsory
retirement.
your lordship.
So when is the difficulty? Who are you, sir?
The allegation was the lordship too. My ground that.
So your allegation was that you being an officer
Yes.
of the bank
Yes.
disbursed lot of loans, several loans to a particular family.
Your lordship, his family members.
All this money was given to them
Yes.
without following whatever the norms, without disclosing that whether you have any relation with them,
Yes.
but you of your own disburse.
Yes.
So that tantamounts to a misconduct on your part. Now the bank, they initiated a proceeding, they found this fact to be true.
Yes.
Inflicted a punishment of dismissal.
Yes.
You challenge this. The learned signature says
No,
that it
this-
is shockingly,
the
shocking to
respondent
the
challenge.
concerns, disproportionate to the misconduct. In fact, the bank house did not suffer any pecuniary loss because the entire amount which was given on loan was repaid by everybody. So it says that when the bank did not suffer a pecuniary loss, then it is too harsh. Compulsory retirement, honorably shown a path. Then why you are aggrieved, sir? You want to retain a dismissal?
Yes.
May I say one thing?
You are an employer or employee?
I am the employer.
Employer.
Therefore,
I thought he's an employee.
the employee challenge the writ petition. But that has been partly allowed.
Sorry, I was under the wrong impression. What is this, sir? You did not suffer any pecuniary loss. And this was and it is disproportionate.
Yes.
Had you suffered a pecuniary loss, I can visualize. But there was no pecuniary loss suffered by you.
But the respondent bank manager, loss of faith and the confidential loss.
So that is why he should not remain there, because you are an employer. You should maintain a discipline, some kind of the culture of impartiality, fairness, everything has to be ensured by you. That is what is.
That means admit to lordship. There lordship is.
What written? Sir, there is a very limited scope for interference by a red court against punishment.
Yes.
The only problem, the point is that it shocking to the conscience of the court that the punishment is disproportionate to the misconduct. There is definitely a misconduct. But was it of such magnitude that it invites a dismissal? And this is what a discretion has been exercised on a well-settled parameter of law. Then why the appellate court should interfere? Shows the law. It's the conscience of a court. The court has said, my conscience does not permit dismissal. Show us that any other thing. If it is a pecuniary loss, show us that this finding of the single bench is wrong.
Lordship.
Lordship.
Any other, though I am placed for SB Mahanti.
No, we will not grant you, sir. No. After expressing our views, we will not grant it. In every case, we cannot grant.
No,
You have to satisfy that on which ground the learning single judge has ordered. The learning single judge has interfered only on the ground of the quantum of punishment, according to whom the punishment is disproportionate to the charge of misconduct. Therefore, he turned the dismissal order to compulsory retirement.
Yes.
So, when you admit that there is no adverse report against you, against the employee during his service career, nor there was any pecuniary loss happened to the bank, then the punishment of dismissal is disproportionate. And how do you challenge? What is the ground?
Actually point out that the act done by the respondent is disproportionate.
Absolutely.
Lordship.
No, misconduct.
Misconduct.
Not difficult. Not difficult. That is also upheld by the single bench. There is a misconduct.
Yes.
Was it so grave to invite dismissal? Is the question. When the bank admittedly did not suffer any pecuniary loss, because the entire known amount with interest was repaid to the bank by those borrowers who happened to be the family members of the bank manager.
Or the act of the other should be.
You earn profit, sir. Rather, you earn profit. Under the banking regulation, what is your business? Business is to lend money
Yes.
to the intending borrowers, collect the interest.
Yes.
That was collected, the profit came to you. Only thing is that he ought not to have, even to his family members. Or at least he should have disclosed that they are my family members.
Without prior approval, also they have sanctioned the loan. Without any approval, he sanctioned the loan.
These are the, I would say, the misconduct, these are the
Yes.
technical, I would say, the procedural lapses. Does it invite a dismissal? So,
Major penal.
Horse penalty.
What's the name?
SS Mahal.
Hard Mr. Mr.
SK Samant.
S.K. Samal.
Samant.
For the
My name-
Samantraya, for the on behalf of Mr. S.V. Mahanti.
Yes.
For respective parties. Stop. The present appellant is the bank authority, Gramya Bank Authority, who imposed penalty of dismissal against the respondent employee in a disciplinary proceeding. Stop. The order of dismissal was challenged by the employee in the writ petition, and London single judge had impugned order dated 14/11/2024. While confirming the guilt of the employee in the proceeding, interfered in the quantum of punishment to opine that the punishment of dismissal is disproportionate to the charge. Stop. Hence, he ordered to change the order of dismissal to an order of compulsory retirement. Stop. The facts of the case as reveals that the employee respondent, while serving as manager of Patilo branch at the relevant time, was found with certain irregularities committed by him in sanctioning and disbursing in favor of some private parties stated to be his relatives. Accordingly, on 12th January 2004, the charge was issued and charge sheet has been served on him, containing 3 charges. Stop. The petitioner containing 3 charges. Stop. The disciplinary proceeding continued and the petitioner started in the same court, submitting his defense. Stop. There was no irregularity found on the part of conducting the disciplinary proceeding as continued in terms of Regulation 38 in bracket Roman 1 bracket small b bracket small v and small 2i of the cut of Gramya Bank in bracket officers and employees service regulations 2012. The penalty of dismissal imposed after completing all procedural formalities, including service of second so cause notice, comma, the employer has decided the penalty of dismissal and lowering the pay of the employee delinquent to the initial basic pay, to his initial basic pay. Stop. The learned single judge analyzed the evidences and the procedures followed in the departmental proceeding. Stop. According to his opinion, the scope of judicial review against the order of departmental proceeding is very limited, and relying upon several judgments, several settled laws decided by the Honorable Apex Court, the Honorable Single Judge did not find any lapse or lacuna in the procedural aspects of the disciplinary proceeding. However, he found that since there was no adverse report found against, since there was no adverse report against the delinquent during his entire service career, and considering the charges, considering the severity of the charges and the circumstances together, the penalty of dismissal from service has been converted to compulsory retirement. Stop. Upon going through the impugned judgment of learned single judge, we do not find any flaw therein to interfere with at the behest of the present appellant. And we fully agree with the finding of the learned single judge that the punishment of dismissal of service imposed against the delinquent employee is disproportionate and not commensurating the misconduct charged to him. Thus, the findings changing the order of dismissal from service, converting the order of dismissal from service to compulsory retirement is confirmed. The writ appeal is accordingly dismissed. Yeah.
Passport matter item number 1.
This is a intra-court appeal. While before taking your losses, my lord, to the impugned judgment, may I recapitulate my lord certain facts so that it will be easier for lords to appreciate my lord judgment. We're back in the year 2017. The Indian Council for Agricultural Research, they, my lord, wanted appointments in the post of senior scientist. In several disciplines, my lord. One of them was senior scientist in horticulture. I was working as a junior scientist in horticulture in the Odisha University of Agriculture and Technology.
So we wanted a equivalent degree in this regard.
No, my lord.
Contention.
We never wanted money. What happened is, we were working there from 2005 to 2017.
Yes.
When 2017, this advertisement came, my lord, I applied for the state post.
Because you are botany.
I am a PhD botany.
We wanted that it should be equivalent to horticulture.
My lord, the expert committee, my lord, they decided that it is a subject which, wherein I have done my PhD, is equivalent to that of horticulture.
I really wanted to say.
Well,
Now, who is the competent person to decide that?
the selection committee, my lord, experts, they have already decided. I worked there for 45 years, my lord, from 2018 onwards. Yes. I worked as a senior scientist horticulture from 2018, my lord, to 2025. And 2025, learning English, my lord, without taking into consideration of this fact that
Then why you approach the court?
I did not, my lord.
Then who approached?
The other person who was not selected, he approached this honorable court, my lord, and his plea was that, look here, he was having a PhD in botany. I am having a PhD in horticulture. Therefore, his PhD in agriculture and horticulture. And your lordship may kindly, for a minute, my lord, this may kindly see the advertisement. The advertisement clearly specifies, my lord.
What is that?
Page 71, my lord. Lordship may come to page 72. Writ petition, my lord. In the writ appeal, we have annexed that writ petition.
Page 71, running page.
Running page, my lord, page 7. Lordship may kindly come to page 70. It starts from page 71. Now, Lordship may kindly come to page 70.
Yes. Roman 3.
Yes, my lord.
PhD degree in the
Relevant subject. That is what was the. Now, Lawrence English, my lord.
So the sixth essential qualification is the minimum second class bachelor's degree.
I have all those. I have all those.
In what is this? I did not read.
In agriculture,
Agriculture.
horticulture,
Horticulture.
engineering, technology, veterinary science, fishery science, home science, forestry, with at least I have all those things, my lord. I have done my MSc in horticulture. I got my national eligibility test. I qualified
Yes.
in MSc in horticulture, my lord.
Yes.
I worked there as a junior scientist in horticulture in the same university, my lord.
Yes.
And then, my lord, lordship may kindly come to my PhD and the petitioner's PhD, my lord, per minute.
What is that?
My lord, it is there. Petitioner PhD, my lord, may kindly see page 75.
Yes.
Subject, my lord, may kindly see. Subject is title of the thesis, my lord. It's a PhD in agriculture. Degree this university and result of his bio examination. You have been admitted to so and so. Last page 75.
Five. Bottom. I that.
Well, that is that you are the board of examination and that on their adjudication of the undernoted thesis submitted you for
This is the PhD in agriculture.
Yes, my lord. My lord, writ petitioner. Writ petitioner got his PhD in agriculture. Lastly, they have written in horticulture. What's my kindness?
Yes.
Now, title of the thesis, lots of my kindness. It's a bottom.
Site, yes, site is specific.
Site specific nutrient management of elephant
food yard.
My lord. Now, lots of my kind. Page 79. Integrated nutrient management.
This is a thesis.
Yes, my lord. Both of us, my lord, we submitted thesis.
Yes.
The only thing is in Utkal University, my lord, we have only botany department. As your lordships know, botany is the mother department, my lord.
Yes.
And one talks about, my lord, the plant, the morphology of the plant, the anatomy of the plant, whereas horticulture talks about, my lord, the management of those plants.
And agriculture?
My lord?
And agriculture?
Agriculture, my lord.
Agriculture talks about what?
Agriculture is overall, my lord. It doesn't. Agriculture also is a comprehensive, my lord. Both horticulture as well as
Is botany is not the mother of agriculture?
Well, yes, madam. Yes, madam. I completely agree. It's mother. It's all comes from biology, my lord. I should not.
You have in botany,
Yes, madam.
he has in agriculture.
My lord. That's my point, my lord. I completely, that's the reason I wanted to go into that.
I am appearing with us.
He does an horticulture. What botany?
Lord, I will. May I clarify that I was appearing for the repetition. It is in horticulture. In fact. Not-
Now, Lord Supreme, kindly come, my lord, to the counter affidavit which was filed by the university authority. May I place, my lord, from para 3, page 99. That reply to para 1 of the petition submitted.
He is the reference Vishwanath Sahu.
Vishwanath Sahu with the petition. Yes,
You are.
I was a selected candidate, my lord. My-
You are Anita Mohanty.
Yes, sir. May I place, my lord?
Yes, so if the advertisement does not really specify the botany to be a part of it. Then, it is ignorant.
My lord, the subject is in the relevant subject. The language is
The relevant subject means definitely for which it is to be done. So what was the subject? Senior.
scientist in horticulture. My lord, I worked there.
Horticulture.
I worked there as a junior scientist horticulture
Okay.
in the same place.
So if the PhD has to be in horticulture,
My lord,
then it's a relevant subject.
PhD in horticulture, my lord, no doubt about it. PhD in horticulture, but
Relevant
PhD,
subject is.
my PhD in botany. He also got a PhD in agriculture.
No, agriculture. You see, there is a
Agriculture and
difference. There is a difference
My lord,
between botany and agriculture.
my lord.
Agriculture includes horticulture as a part of it. So what his contention is that he has gone PhD in agriculture, in horticulture.
Yes. But I have got a PhD, my lord,
In
in the
botany.
relevant subject.
In
the
botany,
relevant subject, my lord.
that is what.
It's not a
the case
relevant
was.
subject.
My lord, the word relevant, my lord.
Word relevant has with the subject.
Yes, my lord, the horticulture, when it comes to my lord, PhD in horticulture, relevant to PhD in botany, my lord. That's the my lord authorities. When I got myself appointed MSc in horticulture, I got my lord. I did my
You were appointed in what post?
junior scientist, my lord.
Junior scientist in what was that post earmark? What was the educational qualification?
That horticulture, MSc in
To
horticulture was
work
there, my lord.
that as a junior scientist.
That is
you
what-
were there. Where is that? Junior scientist. Then how can she be deprived to offer her candidature for the senior scientist in the same relevant subject? This is what our condition is. Let the eligibility criteria of the junior scientist.
I'll make your
Yes, my lord. Even my lords may, they'll produce that document. Lord, what submission, my lord, my humble submission, my lord, that appointment to the post of junior scientist was made pursuant to a different avenue.
If the eligibility criteria which is there has been shown the same as in case, except the PhD, then we have to consider it.
My lord, let them produce
Because
that.
she's saying that when I'm working as a junior scientist, how can I be deprived to offer my candidature as a senior scientist in the same relevant subject? Because she's saying that in the horticulture she's a junior scientist.
My lord, they,
So let us see
yes,
what are the
my lord,
qualifications.
But my lord, one thing, my lord, they have not been deprived. They submitted the candidature, it was assessed, it was accepted, and thereafter assessed. And they have also been given appointment. But my lords may kindly see what it
You have challenged it that your
lord,
appointment has
my
not been
PhD
given.
My
So why-
PhD, which was shown to my lords, that is my lord, may kindly see page 70.
Why you have closed the writ court, sir?
My lord, because my lord, the advertisement clearly specified 7 subjects. What was not a subject, horticulture was a
That
subject.
means you are challenging the appointment. You say that
Yes.
everybody was appointed. If you are happy with your appointment with her appointment, then why you have approached the court?
We are not, we are challenging the appointment.
That's true. That means you are standing in the way of her appointment as a senior scientist.
Well,
So let her come with these documents.
well,
Let us see.
well, let me show the documents, my lord. I will only show 2 pages. If my lord may kindly, just for the sake of discussion, academic discussion, my lord, 2 pages. My lord may kindly see the advertisement first, which is at page 71.
We have seen that.
My lord.
We have seen there is no question of any botany to be included there.
My lord.
We have
That is
seen
all.
that.
My lord.
What do you think?
My lord, that is the only thing, my lord, will.
That's why we are asking him
My
to produce
I
that
bow down.
document.
My lord.
For that reason, after noticing that,
My lord.
Well,
was,
not today. Give this
uh,
next week.
when
Next week, man.
this is the battle in the next week. In the meantime, the prisoners have produce the eligibility criteria for the post of a junior scientist within bracket horticulture in the same department,
Same university.
same university,
Right.
of the same university. Produce
I'll find that out.
50.
Deeply.
Item number 7.
Legal lawsuits. The petition of the lawsuit is challenging direction of the the sales tax department as an annexer 1 to pay a sum of rupees 58 lakhs somewhat within a stipulated date. Well, that's the reason for challenging this order, challenging on the ground that this is illegal. I'll take your lordship briefly to certain facts. What has happened, madam? What happened when the Odisha Income Tax Act came into force? It was challenged in 2007 or 8 by most of the dealers in the state. Division bench of this honorable court held that those goods which are not manufactured in the state of Orissa brought outside the state of Orissa cannot be subjected to entry tax matters. But those who are produced here, when it is going to the local area, that will be subjected to entry tax matters. This was challenged both by the dealers as well as before the Apex Court. Apex Court made an arrangement as an interim measure that you pay 1/3, 2/3 will remain abeyance. Then, my lords, it was referred to a 9 judges bench. As your lordship remember, the 9 judges bench held that no. Entry tax is leviable whether your goods are manufactured outside or when brought inside the area or not, my lords. Then on 27th of March 2017, their lordships upheld the VAT. Then, my lords, what happened, my lords? Immediately petitioner before lordship paid the principal amount and calculated the interest that I'll take your lordships to the statement. 2/3 tax paid, my lords, at page 84, my lords may be pleased to see.
You paid off that remaining 2/3 amount.
2/3 amount and
Along with
also
the
the interest, my lords. Then what happened, my lords? The department started charging interest effect from the date of filing of the return. Now, my lords, the dealers as well as the petitioners challenged this before this honorable. This honorable court, by judgment dated, I have enclosed the judgment, my lords, that is on 15th of March 2023, Annexure 12, at page 154, said that there was a sufficient cause in not depositing 2/3 amount. However, the
From the date of the judgment of the Supreme Court.
Yes.
Interest.
Yes, yes. They will be. Now, my lords, against this judgment, both the dealers as well as the state went to the Supreme Court. Now, Supreme Court passed some interim orders that your lordship will pass, see at page 287 to 291.
What?
They are saying that you pay the principal amount and matter will be taken up after 6 months. Now, as per my information is
Till date, not.
my lords, they said you pay principal amount.
No difficulty, but what has happened to that? The Supreme Court?
Supreme Court is pending matters.
That is what I'm saying.
Yes,
It's pending.
pending. Now, my lords, during pendency, the department, the assessing officer has, by Annexure 1 at page 27, has directed, he has calculated the interest from the date of filing of the return at the rate of 9% matter. That is the difficulty matter. When the judgment came into force,
So according to you, when you are charging from the date of an application,
yes,
and then when this court,
Yes.
in an earlier round of litigation has held that it should be charged from the date of the judgment of the Supreme
Yes.
Court,
man,
then in that event, it is illegal and per se not permissible.
yes,
Now, the matter is
before the Supreme Court.
Supreme Court and
Yes.
there is sub judice there.
Yes, and
By
my
way of
lords,
an interim arrangement, the apex court has directed all these assessees to pay the principal
principal
amount,
amount, that also
which you have, according to you, have already been paid.
paid and
Even in excess amount of interest has been paid.
Yes.
Not applicable.
He's disputing.
I was the arguing counsel. I was the arguing counsel in that case also. That is not applicable. Let me place.
So that is the sum and substance of your
Yes.
argument. Let us hear him,
Yes.
what he says.
Man,
Your Lordship, this rate petition may not be maintainable because it amounts to review of the judgment of this honorable. Your Lordship, why I am submitting this? Your Lordship, for a moment. Your Lordship,
What review?
Your Lordship, let me please. Your Lordship may kindly turn to 154. Has directed by this petitioner was before this court by challenging the levy. This court has three directions were there. Your Lordship, three direction is that the first direction that they have to pay the principal, 2/3 principal, which has been withheld. Second is the interest with effect from 28th March 2017 from the judgment of Honorable Supreme Court. And the next direction is that the department is to levy, they have to pay, not levy, they have to pay compensatory interest with effect from the date of 2010 to 2017 during pendency of the SLP before
At the
Honorable
rate of
Supreme Court
10%?
at the rate of 9%.
Nine.
Your Lordship, on the last occasion, I have placed the enter and Your Lordship has gone very quickly, Your Lordship. So these three directions were there before this Honorable Court has passed three directions in 2023. The petitioner has chosen not to challenge this order, the judgment of this Honorable Court. He has accepted. On his acceptance, Your Lordship, this demand has been
may I
made.
submit? Man,
This demand percent pursuant to the direction of this Honorable Court
From the date
has
of,
been,
from the date of the judgment.
Your Lordship, not just date of judgment, 9%.
Oh, that's a
The
compensation.
compensatory interest 9%.
9%.
Your Lordship, the demand has been raised.
Yes.
So far as the Honorable Supreme Court pendency recently, Your Lordship, nowhere, neither we have gone, department has gone to Supreme Court by challenging that 9% and department's prayer that it should have been 12%. And their prayer, it should have been 0. Since the petitioner has accepted the order by not challenging the order of the Supreme Court, and pursuant to the direction, Your Lordship may kindly turn to the direction only one paragraph. Your Lordship may kindly turn to
Then
the
who has gone to the Supreme Court against?
petitioner, Your Lordship. It is
And what was the interim order passed there?
in the model, particular individual petitioners, Your Lordship, only in some cases, so far as the interest, the principal subject to payment of principal, but the no coercive action. Only no coercive action. There is no stay of the judgment of this Honorable Court. So the judgment of the Honorable Court is binding on the petitioner since it has not. And Your Lordship may kindly turn to the finding, only one paragraph, Your Lordship, the compensatory interest paragraph. Your Lordship has already gone through 284 pages. to strike balance between deprivation of the state of Odisha to utilize 2/3 of the amount of tax in September 2009 in March 2017. At the relevant point of time, and non-payment of full amount of tax liability in the return during this period by the petitioner. The aforesaid unpaid entry tax for the period during which the interim order dated 30th/10/2009 as modified by the order dated 3rd February 2010 passed by Supreme Court 5 by the state of Odisha in appeal bearing number SLP number so and so as operational is directed to be deposited. Deposited at the rate with a simple interest at the rate of 9% per annum based on the principal enunciated. So and so. What is the input order now? Your lordship may kindly look into the input lordship annexure 1. Annexure 1, your lordship, page 27. Your lordship, annexure 1, the above demand of interest has been raised against you after the Honorable Court had judgment dated 15th March 2023. That judgment disposed of batch of writ petition main case so and so, wherein your case was disposed of by the Honorable Court along with Sri Bharat case. You have filed 2 writ petitions bearing WPC number so and so for the period of so and so along with your lordship. In your representation, you have submitted the department has filed SLP but before against the judgment, you have requested to grant skill disposal of the SLP. The undersigned view is that nowhere Honorable Supreme Court has granted stay of the operation of the judgment dated 15th March 2023. And in your case, you have not challenged the said judgment before Honorable Apex Court. And as such, said judgment attained finality for you. Now, after disposal of the writ petition filed by you on 15th March 2023, you have no right to challenge the same issue before this forum, wherein you have accepted the ratio of judgment dated 15th March 2020. My respectful submission before your lordship, if two points, your lordship, if the order, this judgment has been accepted Supreme Court by the petitioner, then this is a matter which your lordship, this is, and your lordship on the last occasion, your lordship might have remembered, even Supreme Court has granted stay. Your lordship was directed to get a clarification from the Honorable Supreme Court while your lordship was sitting with Honorable Justice Arindam Sinha, your lordship. In that case, your lordship had nothing. And in this case, it has been accepted. And in no case, your lordship, your lordship, in no case, neither in department nor in any of the petitioner, this judgment has been ever stayed, your lordship. Judgment is operational and it is accepted. So it amounts to review. For that reason, I have submitted that it amounts to review the judgment dated 15th March 2023.
Not review.
Not may I now submit matters? If your lordship kindly give me that chance, may I submit matters? Had my learned friend finished?
Obviously, you are
very much obliged, matters. Matters, the judgment dated, which my learned friend has relied upon, that 15. I was one line. Now, just a minute.
One line with greatest, but that so far as that order, what he has submitted by this Honorable Court, another order, identical order, your lordship. In that case, the petitioner is not a party. In that, for that reason,
now, my lords,
you were a party. You were a party.
I was a party.
Now, challenge the order before the Supreme Court.
My lords, this is a judgment. I admit that.
Are you a petitioner in the special petition? Any of the special?
No, my lords, this is judgment in rem. This is judgment not in person.
That's it, because every demand constitutes a fresh order of action for that.
My lords, quite right.
So now, my lords, it is in person more than in rem.
My lords, it is, my lords, whatever may be the outcome of the Supreme Court will apply both to the state as well as to the dealers. This is a settled position, my lords. Because the dealers as well as the state have gone to the Supreme Court. It is not that I have not challenged it. I have accepted the judgment. In what manner, my lords? I have accepted it. If I have not gone, the other dealers have gone. They have.
There are two consequences that will follow from
yes,
from the Supreme Court.
Yes,
According to him, the department has gone
yes,
just to enhance the rate of interest.
Yes.
Was imposed as a compulsory interest for the period
May-
of the
Yes.
application till the judgment.
man,
So according to him, it should be 12, not 9.
nine,
Now the dealers, some of the dealers are gone that they cannot compulsory the interest
Yes.
for that interregnum period.
man,
We
Right.
appreciate it. If
Right.
ultimately the court decides,
man,
the impact of such judgment has to be seen from there
man,
at that end.
man,
Now, so far as the balance is to be created,
yes,
in that event, if you deposit,
man,
ultimately, if the judgment in rain is passed,
man,
it will be not to the benefit of all in the country.
man,
You will
may
get the either a refund or you will get the rebate,
Manus,
whatever
Manus,
that
may-
is there.
may take your lordship. I definitely, Manus, I am obliged. Manus may kindly see page 291, the order passed by the Supreme Court.
Yes.
There, my lords, the lordship, I just placed that order of the Supreme Court. We direct that the respondent dealers in the civil appeal number so and so to file affidavits indicating compliance with the direction by this court on 25th of April 2024. They shall produce the evidence. I have paid the principal amount along with interest by calculating myself.
Interest for a period from the date of the judgment of the Supreme Court.
Yes, from the date of the judgment of the
Their
Supreme
contention
Court.
is that what would happen to an interest from the date of an application till the date of the judgment?
Date of the filing of the return. That your
That is
lordship
what
is
is,
asking.
that is what
Yes.
is a return
Yes.
till the date of the judgment of the Supreme Court.
Yes,
According
That
to
is-
him, by virtue of the order of this court,
yes,
the compensatory in the interest of the benefit is leviable. They demanded that.
they have now, yes.
Now
my
they
lord.
have demanded.
Now,
Now the
because,
matter is before the Supreme Court to
Yes.
decide.
yes,
You are not a party there.
I am not a party as yet.
You were a party in the judgment of the High Court.
Yes, my lord.
So in that event, for the time being,
Yes,
since you have not gone there,
yes,
impliedly you have accepted, whether it will be a judgment in rem or a judgment in personnel,
may,
is the Supreme Court who has to decide.
yes,
At the time of deciding, may hear
may,
that whoever has come before me, this judgment would operate only in respect of them, not in respect of all.
may I,
So we don't know what will happen. So show your bona fide.
my lords, if your lordship may permit me, my lords, I will pay my lords 50% of the amount and rest of the amount will be 50%.
Why? Then there must be some justification in this regard.
My lords,
We
the all
can
else,
say that whatever the payment,
but all
it is
else,
subject to an outcome.
my lords,
We
all
can say it's a
else,
subject
all
to-
else, lordship may grant some time to face it, some time
What's that?
against the judgment.
It is 2023.
Judgment was passed in 2017, sir.
My lords,
Now you are in 25.
my
I do not know what will happen.
23,
23, the batch of them.
Oh, this batch.
23, 23 and 25.
Mallards. Now, mallards, somehow or other mallards, mallards, what I pray mallards, I will, because this is a financial stringencies mallards, I will deposit 50%. Voluntarily,
It's a relation to a revenue. So that means, the interest of the revenue will also be taken into account. We can definitely say that it will all be subject to the revenue.
yes. Mallards, then your lordship may grant some time, at least 2 months time to deposit this amount and subject to the result of the
Whatever, subject
yes.
to the outcome.
of the, yes, 2 months time.
We
yes.
don't know whether that judgment will operate or not. Everything
Yes.
will be settled.
Mallards. 2 months. And after or else, madam, I will deposit 2 months.
2 months also with interest.
Yes.
2 months more interest.
Yes.
What is
Better.
that? 1 month is a gasping period.
Your lordship.
2 months will be subjected to the result of the Supreme Court.
Provided you are there. Provided you are there. The demand
Demand is Annex 1, man.
Next one, page 28.
58 lakhs.
For payment of the interest. Or
At the rate of 9%, Lordship may kindly indicate
at
that.
the rate of 9% from the
From the date of
from
filing
the
the
date of
return.
filing the return
Yes,
till the payment
yes.
is raised with a number 2327/CT and GST dated by 2/2025 from the petitioner. The challenge is made to the said demand on multiple grounds, including that the spate of litigations initially poured in the docket of this court, assailing the demand of the entry tax under OET, which act which year?
99.
99. And the same was decided in favor of the SSE, upholding that their contention that that it is ultra virus.
No,
I said that there was sufficient cause in not deposing
that is
to
not,
that amount.
that is not. Your Lordship, in 2008,
Yes.
in case of Reliance Industries versus State of Orissa, this Honorable Court has decided the Entity Tax Act is intra-virus, and in the said judgment at para 30,
Was held to be intra-virus.
and in at para
And
30,
those goods
And further direction.
not outside the state, not manufactured here.
Direction were passed in relation to modalities of the transactions. Modalities of the transactions.
Your Lordship, the particular language,
And or outside the
the
state.
particular language in that judgment, entity tax can be
We are
levied.
not going to say
Yes.
these the modalities within or outside both have
Correct,
been
ma'am.
provided. We are not going to say.
Yes.
Your Lordship.
The matter traveled to the apex court. And it is decided, and an interim order was passed. Directing the SSE to pay 1/3 of the demand. And the rest portion of the demand was kept in a bag until the final decision is taken. It is not in dispute that the civil appeal was disposed of by the Supreme Court on what?
28 March 2017.
28 March 2017.
In case of State of Orissa,
Uphold the virus of the act
and reverse para 30.
and the competence of the SDC and the competence of the department to impose the tax in relation to the transactions is specified therein. Despite the decision having taken by the apex court, the litigation did not receive quitters as batch of writ petitions were filed before this court, assailing the decision of imposition of the interest from a period,
From the date of filing.
from a
of return.
period as demanded by the department. Those writ petitions were
Admittedly, the petitioner was one of the
Applicants.
litigant in the said batch of petitions, which were disposed of
15th March
15th March
15th March 2023 with 3 directions. The remaining amount equivalent to 2/3 of the demand shall be paid with an interest from the date of the order of the Supreme Court. Secondly, so far as the interregnum period from the date of filing of the return in the judgment of the Supreme Court, as aforesaid, a compensation at the rate of 9% shall be charged on the SSC by the department. And what is the third?
There is a two.
That is
That is the
principal
two.
argument.
The matter has now traveled to the apex court,
Both by the state and also by the dealer.
traveled to the Supreme Court, both at the behest of the department as well as some of the SSCs.
Right.
And the leave has already been granted. And the civil appeal is now pending. It is not in dispute that the interim order to the effect that no courses shall be taken against the SSC petitioners who approach the Supreme Court is also passed. The petitioner contends that since the apex court has passed an interim order, as the court said, it would inure to the benefit of all the SSCs, whether made party in the civil appeals or not,
Right.
as such order operate in rem
Yes.
and not in personam.
Right.
According to the senior counsel appearing for the petitioner, since the apex court is in session of the matter,
Right.
and an interim order has been passed, the department cannot raise demand on interest
Or take any
for such interregnum period. It is further submitted that the remaining 2/3 amount of tax, along with an interest, has already been deposited by the minister after the judgment of the Supreme Court. And therefore, the petitioner cannot be termed as a defaulter in discharge of their obligations foisted upon them under the statute. The counsel for the department refuted the contention of the petitioner in contending that the petitioner is not a petitioner has not approached the apex court against the order of this court passed on 15th
March 2023.
And therefore cannot reap the benefit of the interim order. In other words, it is sought to be contended that the interim order is restricted to the petitioners, is restricted to the petitioners who have filed the special petition before the Supreme Court, and therefore to be construed as an order in personam and not in rem. It is further submitted that once the writ petitioner has accepted the order of the court dated 15/3/2023, having not before the apex court, the instant writ petition is in fact filed seeking a review of the said order, which is impermissible in law. On the prospectus of the aforesaid submissions to advance, it is no longer in dispute that the batch of writ petitions, including the writ petition filed by the petitioner, were disposed of by a common judgment passed by this court on 15/3/2023, and the petitioner till date has not assailed the said order before the apex court. We have not been taken to any material that the operation of the said order is stayed by the apex, but the interim order is passed against the department to take any course and steps
Condition.
for non-deposit of the
Principal amount.
of the interest / principal amount.
And let's
In respect of the petitioners of the said special petition. Whether the court, the High Court was within its competence to direct the compensatory interest to be levied on the SSE for the interim period between the date of filing of the return and the judgment of the apex court is a matter to be decided by the apex court. Since there is no express order of stay of the operation of the said order, and that the petitioner being not an applicant in the inspection of petitions pending before the Supreme Court, we do not find any justification in extending the benefit of the interim order at this stage. Furthermore, in order to bring equilibrium between the rights of the parties, any deposit as demanded would subserve the justice, as the same would be subject to an outcome of the decision to be taken by the apex court. Provided it inures to the benefit of all the SSEs, whether they oppose the or not. We are conscious that because of the confusion having created in the mind of several SSEs on the applicability the applicability of the interim order, we feel that an opportunity should be given to the petitioner to deposit the said amount within 2 weeks, within 2 months from date. So, such period is the such period of deposit. No, sorry, deposit sharing is without prejudice to the rights and contingent of the party.
Two installment, one installment within this month and another.
That is a.
Without prejudice to the rights of the parties. With these observations, the litigation is disposed of. No other responses.
Just, may I, if your lordship so permits me, I'll just read one that order which I have given, paragraph 4. If your lordship may kindly permit me. If your lordship so be obliged, I will be much obliged. Paragraph 4. Revenue having had preferred a specially petition against striking down of statutory interest appears to have acted at variance by demanding compensatory interest. The writ petition is required to be heard. Mr. Mishra submits the Supreme Court has not stayed any part of the said judgment dated so and so. Counter will be filed by this bill. Just to, I'll be failing in my duty if I don't bring your lordship's kind attention to that. Of course.
Item number 8.
What issue of surrender of the license? What issue of surrender for loss of license?
You have not lifted the balance amount.
Entirely.
Shortfall.
No. As on date, my instruction is he has lifted the entire for that year. He has paid the entire license fee for the year. Entire thing is done. It's no more balance that year. What the collector is saying, beg pardon. Yes. No, of that year. Of that year, 24-25. Collector is not correct in saying that I should pay in advance. No.
So let her take instruction.
Yes.
As per the application, they mentioned that they undertake to make full.
Now they say
Again, I have lifted and paid. I have even more than the required amount we have lifted.
Why? Take an instruction and come back. Let them take an
Very
instruction.
short, your lordship may grant a short time.
15 or 16, any time.
As your lordship please.
16.
Yes, madam.
Mr. Doctor. Mr. God, the senior counsel, Orissa submit that the petitioner has already lifted the goods which was
Lifted the quantity of MGQ for the year.
lifted the shortfall quantity of the
MGQ.
And also paid all the requisite license fees
For the year
thereupon. So what is her name?
For the year 24-25.
For the year 24.
Right.
What is
Aishwarya Das.
yes, Sonia?
Das.
The additional government?
Additional standing counsel.
The additional standing council submits that though the prayer is housed in a different pattern in the instant petition, but in view of the submissions advanced by the London Senior Counsel, she is required to take necessary instruction. She thus prays for an accommodation. Let this matter be listed on 16th of April to enable Ms. Das to take necessary instruction.
One more small indulgence.
Yes.
I have filed one IA because some development had taken place in between. Did that IA come on 16 along with this?
So
I'll give the number. Give this.
Send your junior to
Yes,
perform.
Great.
Item 9.
Yes.
Yes.
In the case, my petition, very short point of consideration before lawsuits is that it is clear.
Before it starts, my lord, I think he has filed an interim application at flag C. Copy is not served on me. I have to see what is that copy application.
Yes, yes, I'm sorry.
Then let it come tomorrow, my lord. I will see that so that I can reply. My lord.
Mr. Misro, planning council for the is directed to serve a copy on Mr. Bag, Learning Senior Counsel, who enters appearance for OP
Number
number
9.
in course of the day.
Yes, my lord.
Decision 15th? 15th?
Yes, my lord. Yes.
Yes, my lord.
List on 15th.
16, my lord.
15th.
16, I can.
You want 16th?
No.
Yes. Only 16th.
No, sir.
16th. April.
Item number 10.
Great.
May I please?
This. This is the site.
So this is a challenging the construction of medical sub-center. It has been approved and sanctioned to our village. Now the authorities are going to construct in another village. And you see, Annex 2, page 15 million, relevant is page 119.
19.
Yes, million, relevant. Serial number 37. Hello. New construction for
Ranpur.
19.
This is
Page number 19, serial number 37, 37.
37 is a Ranpur.
Yes, Milo. Yes, Rampa medical sub-center of Rampa. Now, Milo, they are going to
new
construct.
construction. This is
Who are you?
Sub-center building.
Who are you?
You are the villagers of Rampa.
You are the villagers of Rankadevli. It
Yes,
was
ma'am.
decided to be constructed at village Rankadevli.
Yes, Milo.
Now they are shifting it.
Yes, Milo.
Where?
To where? To which place?
Now, page 23, 23 annex 4. Relevant is 24.
You have not annexed a translated copy. You do not know.
Nice, sir. They
I can't read.
in English, written on a medical sub-center Rampa. 24.
It is a medical sub-center, but where?
But this is at village.
Mauja.
Another
Na?
village. Mauja.
Mauja.
Mauja Malise.
Your village is of Mauja. Which Mauja?
Rankadevli.
Your village is of Mauja Rankadevli.
Yes, Milo.
So now they have decided to those other Maujas.
Report that this is the.
Kindly answer, sir. Listen.
Sorry.
Listen to us, then answer it. So these Maujas do not belong to your village.
No.
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 Where you have said in the writ petition?
No, that is another village in Lord. Rankadevli and Malisai, both are two different villages in Lord.
No, there is not only Malisai, but also Khatia, Malisai, Lodukeswar, Darpanaranpur. There are 4 Maujas.
That is under RI.
Whatever, it doesn't belong to your Maujas,
No.
to your village.
No. Our
Where have
village
you
is different.
where have you said so that these projected or proposed Maujas are not the part of village Rankadevli?
Operation is Yakida.
Submit in English. What are you saying? Say in English. My lord is.
Problem is because of the cataract surgery, unable to read properly. Pleading. But it's a fact, they are going to construct another village proposing. But
What is your stand? What he's saying is correct.
My lord, through that effect, I have to take instruction because this is an RI inspector's report only, my lord. Whether a decision has been taken pursuant to this.
It's 25.
And now we have given a representation of the collector and other authorities also. Para 17.
You take instruction.
Problem.
Ms. Das, London Days, date instruction. List on 22nd April.
Item 11.
They are status.
No.
They are
This is a welfare project wise.
problem.
Item number 11.
While here, I'll draw my lordship's article to Annex of 5 at page 25.
Pursuant to last order, we have received instructions, my lords, in this matter. My lords, in the instructions, so what is mentioned is the instant case, although the tender was invited on 21/7/2017, the estimate was prepared inclusive of all the taxes. However, what is the differential amount, whether the amount has to be recovered or has to be adjusted, that amount, differential amount has not been calculated. In 2 months' time is required for calculation of the amount.
They wanted the return of the money with interest.
My lords,
So if you have overcharged them, and you notice.
only one submission, my lords. In petition, my lords, they have fixed a standard rate of 12% for all the items. However, because the tender was inclusive of all the taxes, so amount has to be adjusted, whether that amount has to be deducted and 12% has to be added. So the differential amount has to be calculated, my lords.
What is the date of tender?
The date of tender is 2018, my lord. Sorry, my lords.
Final bid.
He executed on 18/1/2018.
Yes, my lord.
Tender date?
Execute it on
The contract,
Tender was in-
if the contract says that it was the GST, then in that event, can you charge the GST amount? So let them file the affidavit. Let them
My
file the
lord,
affidavit.
GST Act came into force. GST Act came into force on 1/7/2017.
Your
And my
tender is
contract,
prior to that.
my contract is 18/1/2018.
Then in that event, you can't, because
My
the
lords, but what instructions what I have received is the tender was invited on 21/7/2017. The estimate was prepared inclusive of all the taxes, my lords.
at that point of time, the GST was not there.
Yes, my lords.
So if there is some subsequent levy, then in that event, there must be a clause.
Yes, my lords, there is a government of Odisha circular which entitles them, according to, my lords, the department has mentioned that the differential calculation of differential amount is not complete. For that calculation, they need 2 months.
You make a calculation, whatever is there, if it
Yes,
is inclusive of the VAT at that point of
Yes, my
time,
lords, yes, my lords.
then what was the rate?
Yes, my lords.
And now, if the rate has changed, then you'll have to pay the differential amount.
Yes, my
The
lords.
57 they are taking. Because my lord, the agreement was executed 18/1/2018, the tender was called for. And the GST Act came into force once.
What he's saying that at relevant point of time, when you entered into a contract,
Yes.
there was no GST.
No, that's the GST. That was GST.
Oh,
Yes, right. Kindly, for Annex 5, my lord.
You take instruction, you file a reply.
My lords, I'll file it.
A short date.
Mr. Jaina for the petitioner and Ms. Das London Days. Issue notice. Ms. Das accepts notice for the opposite parties and submits to file their reply affidavit. Stop. List on 30th April.
Item 12.
Wait for me. I think that's not.
They have served a copy of the counter on me, so wait 1 week extra, maybe call after one.
Mr. Pradhan seeks time to file resender list on 6th May.
Item number 13.
Yeah, this is the consistent instruction certificate, my lord, your lordship's cover. Order.
Yes. Covered. Where are necessary changes? Have you seen that?
I want to find your.
Agree. Yes. Seven.
Item 14.
Which takes something by that. For non-deposit of the just amount of 7.5. In the meantime, lordship, after dismissal, they have supplied the alternate and have already deposited the amount. But kindly the appeal may be restored to the file.
There are similar orders.
Pre-deposit.
Now that's deposited. Because since it says service tax appeal, so my online portal was not operated. That is why I could not make the deposit. I applied before then, they supplied the alternate portal. Thereafter I have deposited.
So now there remains nothing in this.
Yes, the appeal will be fine.
The appeal will be restored.
Yes.
For non-deposit of the statutory deposit amount.
Yes.
The statutory appeal filed by the staff was dismissed for non-compliance of the statutory deposit being a precondition for its maintenance. According to the petitioner, though it intended, it or he intended to deposit the statutory amount, but because of the technical glitch as the portal through which such payment is to be made was not functional and or operative. The department was approached in this regard, and an alternative mechanism was suggested to the petitioner.
Mechanism, that's a converted password. And again, his password then it was.
What I said? The department was approached flagging such issue, and the same was resolved and permission was granted to the petitioner to deposit the statutory amount. The downloaded information /challan from the official website of the Central Board of Indirect Taxes and Customs is handed over to this court in order to corroborate such a stand having taken before us. Stop. Let the same be kept on record. The counsel for the department did not dispute, does not dispute that such deposit has already been made. So it appears from the stand of both the counsels that because of the technical glitch, the statutory amount could not be deposited. Since the same has been deposited after the intervention of the department, the command, there is no justification. No, there is no deposit. We therefore set aside the order of the appellate authority by which was directed to be dismissed on technical ground. The appeal is restored. The authorities decided, the appellate authority is requested to decide this in appeal at an earliest.
Item number 15.
15, your lordship, is a covered matter. The GST, when they put in non-constitution of tribunal, we are not able to file the appeal.
Yes.
Made the necessary modification.
We made the last order.
Yes, sir, lordship. Provided the same order. Made the necessary modification.
Yes. Yes.
Item number 16.
Yes, sir. My appearance.
Government employment.
Minus similar matters are.
Virus.
Rules, second one of that chapter.
5th, na?
12th May.
12th May.
12th May.
List on 12th May.
Discuss point.
No, we are not passing interim order. We will consider that. We understand there was an interim order passed in earlier section, but in some of the requests it was not brought to our notice. We did not pass interim order, and we will consider on that on 12th. 12th. Also to me.
Item 17.
Exactly. Here the petitioner challenged that no transport fee on flower. The lordships are on 5th, the lordships are passed an order, but that is not uploaded. That's have not got.
Which one?
On 5th, lordships are passed orders. Just now it went not there. What file is it? Lordship can pass similar order. File is there. Yeah. 8600 2020.
Same order in WBC
8600. But in that case, annexer 7 is there. Here, annexer 6. First item, annexer 6. Second item, annexer 7. There are two items. Yes, sir. Lots of times. It does not.
Check it.
The sub item is annexer 7. The demand is annexer 7.
Verify the annexes.
Item number 18.
Non-functional of the tribunal one, government, like 15.
Same like 15. Same order like 15.
Item 19.
Notes board on 4th of April. On which date my letter friend the time to obtain instruction as the applicability of the previous order passed by this Honorable Court on the question of shifting of my license. I think my letter friend has obtained.
Instead of instruction, the counter affidavit.
The lordship, the affidavit, because we had to give in some documents also, your lordship.
I will sell a copy of
At the cost of their own revenue.
No, your lordship, what has happened is that according to the last order what they had of this honorable court, that it was still the decision on the shifting takes place, the application of shifting. On that, the day that got over, your lordship. And they said that site, the shop is on a government land, Odisha State Road Transport Corporation. They were told to shift. They gave a site that was made during the inquiry. The local MLA and the local people, they objected to their shifting to that site. The collector rejected it, so did the excise commissioner, your lordship. Then they were again asked that you find a fresh site for your shop. That they applied offline, your lordship. They should have applied online and paid their fees. They applied offline, which was rejected again. At the fag end on 26/3/2025, they applied it on online.
We have depository.
And according to rules, 15 days time is needed for making
Writing
a
objections.
public notice. Since they only applied 4 days before the end of the financial year, that was rejected again by the collective, your lordship, that application for shifting. But in view of your lordship's order, their shops are continuing till today, your lordship.
The extension has been granted
Till
till.
today.
No, till
Today I have an application with a deposit of whatever required amount of fees. Now, on my application, let me kindly see page 86.
But they.
1 second. Kindly see page 86. 1 second. Kindly see, Lord, on this report, but how can they say object to their own revenue? Kindly see page 87. 87? Yes. Page 87. Whatever is submitted, page 87 of my brief, 20th of February 25, on my fresh shifting application pursuant to their observation, they have inquired into my application, and this is the report. With regard to offline, online, there is nothing available here. Kindly see, my lord. Page 87. Findings on inquiry, February 25. This is the preliminary inquiry on my fresh shifting application. Madam, please. This is the letter on which you are directed to. This is the letter on which your lordship intended instruction from her. Now, this is the inquiry that have taken place on 20th of February 25 on my fresh application. And all that is stated before your lordship is not available here. Learned, the authority below has submitted a favorable report. If your lordship would kindly see page 18.
No, 89 I have seen the application
Right.
by such and such.
End of the matter.
May be considered for 15 of the
End of the matter.
from the existing proposed site
End of the
for
matter.
remaining period of 24.
End of the matter.
So once it is recommended, then why?
All this submitted,
They had for the new side, they had submitted a proposal dated 29/1/25, your lordship.
What?
They had submitted an application on 29/1/2025, not this application. We have, and that was rejected. That was rejected by the collector.
No, this is government. This is of 20th February, madam.
When it is rejected by the collector?
The collector commissioner rejected it on 14/3/2025, your lordship.
Which application was rejected?
The application dated 29/1/2025. That was as per my instruction, your lordship. I may make a clarification to this, your lordship, if your lordship allows me another time.
So that rejection order is not with you.
No, we are not challenging the rejection order. We have applied afresh. Therefore,
No, that recommendation of
This application is
shifting
not.
by the inspector that inquiry
it is here. It is here. Page 84. It is here.
I have to take instructions to generate of that
What he
application
says
of
is
February.
that this application may have been favored by the inspector. But ultimately, the collector and the higher authorities, they did not.
Collector has not
they did
rejected it is
They
pending.
did not find it that it is a correct one. That is what I understood.
Yes, your
was.
lordship. The
I
date
think
is
there is a
29/1.
communication gap.
I
think there is a
will
communication.
file an additional affidavit to the genuinity of that
Please.
application.
What is the genuinity? Now there is your inspector. He has written to a superintendent of superintendent of excise.
Yes, your lordship.
Submitted the inquiry report, and the inquiry report is dated 20th of February. Which says that there is nothing, it can be shifted to excise. Now, what the superintendent of excise did there?
Your lordship, I have to seek instructions on that regard. It will be kept on Thursday because it was a short period and then we got it last evening, your lordship. And we have filed this affidavit. Because, and here that date is not there.
This is, I tell you, with all humility and the respect.
I apologize, your lordship.
command.
I apologize, but
When
it-
you have been provided with the writ petitions, you
Yes,
must
Your
have gone. Job the
Yes,
elections.
your lordship,
It is your duty to
They had
deal with all those. It is not when you file a ground. It's not been done in a piecemeal.
Your lordship, the superintendent of Sambhalpur had come yesterday, your lordship, in the evening. I asked
But-
them,
but
they said,
that
we will have
everything
to
you have
find that
made,
out.
will you not ask him while preparing this?
I had asked him, your lordship,
that
but
what is your answer to this?
since your lordship, it was on a Thursday, Friday was holiday, they
Could
came
find a
yesterday.
counter on this.
I had to fight.
This is the previous application. Yes, sir. This is the previous application.
This is the previous application.
My lord, this is with regard to MLA the objection, which was rejected.
So please read out that.
Yes, yes.
Application
Forwarded to ISHI for joint inquiry.
From GEC.
As reported by the collector Sambalpur, shifting application of Ointapalli so and so to a new site is not acceptable due to vehement objection by the local MLA. The EPH
Public.
MLA.
No.
Local public and local representative MLA. The EPH of the said shop has also been directed to find a new location for shifting. Hence, the present application will be rejected in online mode to enable the EPH to submit a fresh application for shifting. But
This is after the inquiry.
Lordship is referring to the inquiry of February, but this application was prior to that. That is what the conclusion is. Later, after instruction of this.
Show that what was that application?
Those applications have to be there before my lord's court. Yes.
Does not appear to be so.
No, there are two applications. Application after the order passed by this honorable court was rejected, we applied afresh through offline mode. We deposited. Kindly see my lord our deposit.
You are according to you, Mr.
Just turn to page 80.
Rejection is not pursuant to the inquiry report, is not related.
No, yes, Lord. I say kindly turn to page 80. But page 85, kindly see. Kindly see page 85. The deposit I am making on 24/3/25. Kindly see. So let there be no confusion on facts. Kindly see at the bottom of 85. This 3 lakhs amount I am depositing for shifting application on 24/3/85. So this is pursuant to a fresh application. That's what I am trying to tell you.
This application has not been considered.
Right. So great.
Yeah, this is the subsequent application. Now you are abandoning that
Yes.
report
It was
of.
offline, your lordship.
Yes.
It was offline.
We have deposited thereafter.
So after rejection on 13th March,
Yes.
you made the deposit for the new land location.
Correct.
What was
Now
that
your lordship
new
has got it.
location?
They have to take instruction on this.
What was that new location?
I have given a new location altogether.
Where is
That is here. Kindly see page 87. Plot number 1535. Khata number so and so. At the top, page 87.
1535, khata number 330.
Right, Melo.
At same Ointapalli order.
That has to be within that location.
So what is your instruction? Have you stated
Your lordship.
regarding this? Plot
Your
number
lordship.
1535.
Your lordship, they had applied offline without paying the shifting fees.
Whatever maybe, you have accepted that deposit.
And,
March.
and then your lordship, on 26/3,
No, you come to page 87. You have accepted. Sir,
that I asked them that,
this
yes, your lordship, that I asked them, I asked the deputy, the superintendent of excise, your lordship. He said to me last night that they had applied it offline and which was not permitted. So we told them to apply online. They applied it on 26/3, which was 5 days before the financial year end.
85 in your counter.
That they applied.
You have filed the counter now?
Yes, your lordship.
Have you answered this? Annexure 19 series. What is your reply to the Annexure 19 series? Give a copy. No.
Yes, your lordship, paragraph 11.
Counter you are filed?
Today it's
Where is it?
in the e-filing. Because your lordship, we state always file e-filing, we have to file it e-filing.
Have you got the copy of the?
That's not. That's not. I got. Can I give it to them?
No, I have.
Paragraph? 11?
11, 12, 13. What should miss?
Yeah, yeah.
Now they are saying on 26/3 I have applied for afresh.
24.
29(1), petitioner had filed a shifting application through offline. The same was not taken in consideration by opposite parties. Subsequently, the petitioner submitted an online application on 26/3/25 for shifting of the shop to new site.
This is obviously after the rejection.
Then why did you accept the which are not? It was shifting on 24th. On 24th, we received the amount, yes, and say that on 26th, because it is the far end of the financial year and 15 days time cannot be procured to invite objection, therefore it is rejected.
They have been doing it in all cases, irrespective of the fact that financial year, no financial year. But I can show dozen of cases they have allowed shifting even subsequent financial year. A dozen of cases are there. I can show it. Then make a statement.
Instructions.
The license has been extended beyond 25, beyond March 25. That's not.
That is why before my last.
Your Lordships, as an interim measure, the Lordships had said that
That
the
is why
shops which shall not be closed, it is not closed.
And it is at the cost of state's revenue. It's a very lucrative shop.
But it's on a government land.
And earlier this Honorable Court passed order at page 18.
How to
I don't think there should be any contest on this. I don't think there should be any contest on this. They should take up a limited time within a 1 month or 20 days or whatever time they require. Till that they consider this. But that's what I am asking. Lordship page 18. Then by an earlier order, it was protected on their agreement. They have renewed our license and by virtue of the earlier order. The same protection I am asking.
That was, Your Lordship, that paragraph, if I read out, 81.
Page 81. Yes, no, 81.
81, Lordship, the relevant paragraph 3.
Page 81.
Petitioner has already applied for shifting with all particulars on 17th August 24 under Annexure 12 series. The authority will consider the application and on petitioners fulfilling and complying with the requisites and formalities order. The existing shop to be permitted to run on renewed license under the new policy from today till the date of passing order of shifting after submitted by the petitioner. This was in a month of August, Your Lordship. And he was allowed to continue till 31st March 2025, Your Lordship.
No, it is not for the new financial year.
No,
Not for the new financial.
It's not for the new, but
Yes,
the
yes, Your Lordship.
direction is
Now it is, he doesn't have a place, Your Lordship. He's running his shop on a government land. The excise commissioner and the commissioner of revenue, they have said that that land should be vacated.
But instructed to apply immediately for shifting
Yes, Your Lordship.
for the year 25-26 after renewal of this order.
Yes, Your Lordship.
So unless the shop is renewed, we cannot apply for. So you have. Madam.
Your Lordship, Annexure A by 4.
That of the difficulty is when you use the words or the expression after renewal of the shop. Renewal means what? In an existing position, one has to renew it.
Your Lordship, there
Are
are
you not
two.
lightly permitting them to run the shop from the same side?
Your Lordship,
You are saying it's
no, Your Lordship, if I may, two excise policies in the previous year. One was from April 1st.
all humility,
till
my lord. They are
31st
speaking the language of my
August.
competitors.
Then there was another policy from 31st August till March.
Policy, what are
That is why the renewal word was used, Your Lordship.
Now, what is the meaning of the word renewal?
The-
Renewal means of the shop means where they are running an existing shop. Is a renewal of the license in the existing shop.
Yes, Your Lordship.
And you are saying that this existing shop is situated on a government land.
Yes, Your Lordship.
So what they have to do? Either they are on a northern side, nor they are on the
Yes,
southern
Lordship.
side, they are.
If I may say, Your Lordship, Annexure 4, A by 4. That was on 31st/7/2024. That was given to all.
Has to be done. They
Yes.
the shifting, they
Yes.
are planning,
There were two.
they are citing, they are visualized, they are proposing a different sites.
Yes, Your Lordship.
Every time you have the problems because the objections are coming from the local side.
Yes, Your Lordship.
What is expected? You say, I do not approve. Please give me another site. We give another site. I do not approve. Please give me another site. I will not approve. How long will it continue?
Your Lordship,
I
Your
just
Lordship, the
want to know,
background
there
is,
must be a-
no, Your
there
Lordship,
must be some end to it.
the background is of the renewal word, Your Lordship, that you used. There were two excise policies for the last year. One was from April 1st, 2024 till 31st of August. Then from 31st of August till March. Now this letter of vacating is
Not on the policy.
no, not policy. No, what has
Whatever policy you are adopting.
yes, your lordship.
Question is after renewal.
After renewal is 31st of August 2024. Because there was another policy, and at 31st of August 2024, A by 4 is a letter.
Probably you are not in a position to appreciate what is passing through our mind.
No, your lordship, what
Please
I'm trying to say is
please
that
consider.
his shift
Now, may I be very careful in our expressions. Please come to E4 of your counter. Please come. Can you see the date?
2025.
When you are issuing this on 28/3, that means the license is going to expire for which year?
2024-25.
Correct. No difficulty. That you understood. Come to the last portion of your application. Hence, you are instructed to apply for shifting of Antapani IMFL offshore for the year 2025-26 after renewal of the shop. Now, kindly tell me what is the meaning of the word after renewal of the shop for 2025-26? How the renewal can come? Renewal postulates there is already an existing license which is given, which is required to be renewed. The shop is at a place where you do not want them to continue. You said that you please propose a new site for shifting. Now, when you say you renew, then can you visualize where they stand? They have to get it renewed, then again apply for shifting. These are the things. Then they have to continue at the existing place. Existing place, you have an objection, it is on the government land. So is it not a double?
And you have accepted a renewal fees.
That was offline, your lordship. That was offline. He had asked for a shifting of things. Now, your lordship, the financial year has ended on 31st/3. If there is a judicial order that you consider for his shifting after 31st March 2025, the authorities will consider. But if without a judicial order, how do we consider, your lordship, with the policy ending?
The materials are available.
Until unless he finds a shop, your lordship, whatever the place that he gave, that was public objections. It was not that we objected. There was public objections there.
There is not a single shop in the state.
So if there is a judicial order that you consider after 31st March 2025 for his shifting, we will consider, your lordship.
Where competitors are there. Large
We
scale
consider that
competitors.
without
And
any orders, how do we consider?
They know it well. They know it very well.
Because these policies are time bound. These policies, these are time bound, your lordship, with the date, cut-off date.
No. 25-26.
Yes, your lordship.
Please,
Because he has been continuing on the basis of this court's order from 31/7/2024.
Don't go for a shifting.
Right.
Continue for renewal 25-26.
Right, I have applied for.
In terms of this one.
Correct. I have applied. I have applied for.
Let the
Yes.
take
Grateful.
when you want, then what? Continue. Comply this.
Yes, I have complied with. I have applied for renewal. I have deposited my fees.
But they, on the government land, your lordship.
Up to you. You have asked for a renewal. They will ask for. They will go
On
for
the
a
government
renewal.
land.
What will I? It's your baby. You have to nurture in your own.
According to the previous order, your lordship, of the court, this honorable court,
Say first the renewal.
he will be given protection till the shifting application is decided on. It has been decided on that application, your lordship. The protection goes.
Let us decide.
The protection goes. So, your lordship.
What protection goes? I do not know.
You have rather given more protection by that letter.
Lordship, squash the decision of ours of rejection of his shifting, and that will be considered again.
Why should I? The difficulty is, please kindly consider that. They have, we can't cancel or watch the license unless there are something which has come, violation has come. You say that this was a shop for which I granted you a license. Subsequently found that it belongs to a particular, say, organization. Please shift your shop. He is shifting he's contemplating to shift the shop. You are continuing in rejecting that side. Maybe public order, public objection, whatever. Now what to do? Either don't renew the license, which you cannot.
Documents for order of rejection of his shifting. We will consider his shifting. We'll take 15 days.
Definitely. I have already got.
I'll do that.
I'll do that.
That will help you.
Lordship, how can he continue to come with land, Lordship? How can he continue?
Then why you have asked for renewal for 25-26? Can you visualize? Why for 25-26?
He doesn't have that. These renewals are subject to a lot of other parameters, Your Lordship.
Take that parameter.
And it may be rejected, Your Lordship.
This is up to you. Then the shop has to be closed.
Yes.
No, will be closed.
What can we do, Your Lordship? We have to go by what is there in our instructions and what is there in our.
The loss of revenue will be suffered by.
Your Lordship, if your Lordship will extend that, no, even after 31st March, though he has come at the back end.
To remove this impasse, may I suggest, ma'am? If a Lordship will.
Your application, subsequent application may be processed.
That's all.
This is what I've been.
My learned friend is not.
That is also what I've been saying.
Offline, on.
I've been saying judicial order, we will obey it. I've been saying, Your Lordship, that if there is a judicial order, we will obey it.
We were really waiting for
I've been saying that if there is a judicial order, there is no chance we will obey it. But without a judicial order, our hands are tied, Your Lordship. Because these are all time bound. 31st March, our hands are tied. If there is a judicial order, we will proceed with it.
Yes,
without a judicial order, even
to.
I've told this to my learned senior here. It's permit and we have no objection. But until and unless there is a judicial order, Your Lordship, we cannot proceed.
You have no option.
We have no option. Yes, Your Lordship. But without the interference of the court, our hands are tied. Because 31st March is over, Your Lordship. That is the sole predicament that I am here with a brief that is restricting me to that extent, Your Lordship.
The petitioner is put in wisdom at the behest of the by the excise department in relation to the shifting of the IMFL offshore from the existing site. The applications, the decision was duly communicated to the petitioner during the currency of the license for the year 24-25 to propose a new site, which in fact was duly complied with. And despite the favorable report given by the Inspector of Excise, the higher officials did not approve the new site on the ground of on the ground because of the objections raised by the public as well as the representative of the member of the Legislative Assembly. Immediately another site was proposed by the petitioner, but to their dismay, it got rejected because of the shortage of the times as the financial year was going to end within a short period. According to the counsel for the department, since the said application was filed after 15th March 2020, and the publication is and the publication in terms of the statutory norms postulates 15 days time for raising an objection. The said application was dismissed by the authority. We do not find any justification in the stand of the authority department. Reject the subsequent applications only on the ground that since the objection could not be invited within a short period of time, more particularly before the end of the financial year, the said application deserves dismissal. Interestingly, another plea was taken that since the application was not filed according to the set norms, that is online mode, it deserves dismissal. There appears to be incongruity between the aforesaid stands having taken before us. More particularly when our attention is drawn to memo number 9/EX dated 28/3/2025. It simply postulates the shorter period and not the one which has been taken before us in the counter affidavit. Interestingly, it was instructed to the petitioner that he should apply immediately for shifting of the said IMFL of shop for the year 2025-26. Such creates an anomalous situation. More particularly, in continuance of the business at the existing site, and an appointing to be made after the renewal of the license is extended. By way of an interim order, we permitted the petitioner to continue at the existing site. As we
I was no such order and record, you're actually verbally.
Justification in the technical stand taken by the department, and because of the shortage of time in inviting the objection, such application deserves dismissal. Since the department has taken a decision for shifting of the said IMFL offshore to a new site to be provided by the minister, we therefore direct the department to decide the same. Treating such application to have been, can you find a new one?
I can. But the fees I have deposited will be the same, because I have deposited the fees.
That deposit has to be treated for that.
Yes, ma'am, that just.
This is no, we, the cumulative issue, what I'm saying.
Can I just plot? One just plot, small request, I'm sorry, with liberty from my lord's. There is a technical snag there. But this has to be prior to 31st of March, which I have already applied. New application will not be accepted online. The portal will not permit us. So that application which are filed on 26/3, that will be considered.
That may be considered.
We therefore set aside the decision of the committee in rejecting the application dated.
You are dated 26/3.
25.
On the ground of shortage of period for inviting objection. The department is dedicated to process the said application. Observing all the statutory norms provided in this regard, and shall take a informed decision in accordance with law. Anything more? Since the license is required to be renewed at the existing site. We grant liberty to the minister to apply for.
We have applied for, we have deposited online.
If not already applied,
Right.
if not already applied. And such applications shall be decided by the authority, treating the same on a priority basis.
Right. Till that date, no course is submitted.
For
Thank you, Your Lordship.
no positive steps will be taken.
So great.
The final decision
So grateful.
taken on the
Great.
application for renewal.
Great.
Thank you, Your Lordship.
But I compliment my learned friend for opposing so meticulously. Through your lordship, I convey my compliments.
Formidable opponent.
Right. And I have never seen her so seriously objecting an application till date. But still,
Still, Lordship, I wanted to get out of the sticky situation. And Your Lordships can only take me out of it.
I have
Opponents from the bench.
I really compliment.
Formidable opposition from the bench also.
Of course. Of course.
Lordship, I just put it up because I was in a sticky situation. Your Lordship could only
So nice.
help me out.
So grateful.
Thank you.
Item number 20.
Yeah.
That is my 21. This is 20. Item 20.
What is this?
Rising order, perspective order, to non-constitution of tribunal.
8% of good order.
Have you seen that order? Disciplinary changes?
Yes. I've not seen the same much.
See it and then. Yes, next.
Item 21.
21 will still covered. 180 ml was not provided.
80 ml.
Yes, Lord. I've given copy. The lordship's order. It has been fixed to feed.
Yes, 180 ml.
180 will same order.
Next.
That will tag with that.
Yes.
Item 22.
Your Lordship, I'm appearing on behalf of Mr. Agarwal. Your Lordship is not very, Your Lordship. I'm challenging the ex parte order, Your Lordship. I was issued a from the tax department, Your Lordship. I have filed.
You are quite conscious of the fact.
Yes, Lordship.
Yes, what is this?
Lordship, I'm challenging the ex parte order, Your Lordship, which is under Annexure 3, Your Lordship, at page number 20, Your Lordship. In this case, the department issued me a show cause stating that there are some discrepancies in the tax returns which I have filed, Your Lordship. Accordingly, after the show cause was issued, I have filed my reply, Your Lordship. In the reply, they have passed an order stating that the reply is insufficient, but they have not offered me any opportunity of hearing, or further they have not
clarification.
Yes, Your Lordship, they have not opportunity for any clarification.
Your Lordship, so for the ex parte order, I should not have raised any objection, but unfortunately, Your Lordship, this is the order dated 19/12/2023. Your Lordship, since 2023,
Your Lordship, when it was communicated
on the same day, Your Lordship, 169(1).
Your Lordship, it was just
20.
what we were doing for
Page 20, Your Lordship.
Your Lordship, it was never communicated. Your Lordship, it was just uploaded in the portal, Your Lordship.
That is
It was not in my knowledge, Your
That
Lordship.
is
It came into Your Lordship, I have taken a specific government with respect to that. It came into my knowledge in March, Your Lordship. That is, Your Lordship. That
You
is
are
very commendable.
he is a registered dealer, Your Lordship. 169(1)(d). 169(1)(d) is very clear, and he is a registered dealer. Every month and quarterly, maximum quarterly, he has to file a return. And it is in the portal, Your Lordship, he must have filed within 2 years 16 returns, Your Lordship. And 16 times he must have been seen in the portal, Your Lordship. How can you say that it is not within his knowledge?
It was not within the knowledge of him, and I will be rendered remediless, Your Lordship.
How can you say that? You have to substantiate that's knowledge. They say is a statutory.
It was uploaded.
Statutory notice or knowledge which is given.
No, Lordship, I bowed down with the submission that it was uploaded in the portal. I'm not denying that, but it was not in my knowledge, Your Lordship. I have not seen the portal, Your Lordship.
What is the mode of service of the order? Statutory provides any mode for service of the order.
No, Your Lordship. It has to be uploaded in the portal, Your Lordship.
Therefore, if that is already uploaded, that is a sufficient compliance of the statutory provision.
Lordship.
You cannot say that you should be communicated by a post, you should be communicated by inviting the letter or something or something. You can't.
Consider my application, Your Lordship.
Is a mercy.
More so.
Is a mercy.
Your Lordship, more so. Your Lordship, mercy, Your Lordship. I leave it to Your Lordship. I leave it to Your Lordship.
It is up to you. Up to you.
Your Lordship, even 70.
If it's consent, then we'll record a consent.
Your Lordship, without recording my concession, it is Your Lordship can.
Then we'll have.
Your Lordship himself, he has stated in his submission that no personal hearing is required. Himself, Your Lordship, at page
It's not a
16.
question of personal hearing. It's a question of ex parte order and it's a question of communication. He has come up and said that it was not within my knowledge.
That I cannot
So
consider.
this is what I would say. And he wanted that ex parte is done. Please permit me to give a clarificatory explanation.
Only on that count, Your Lordship may fix a time bound manner. That
No,
you
provided
are-
you give the consent. Otherwise, you can't.
Your Lordship, because Your Lordship, GlaxoSmithKline, Your Lordship might have gone to that judgment of Honorable Supreme Court. Your Lordship, how can I? This is not maintainable, Your Lordship.
Yes.
Your Lordship, 2 days time may be granted to me, Your Lordship, that I will substantiate that why it was not in my knowledge, Your Lordship.
No, after knowing our view, we will not.
You were given an opportunity to plead
Lordship,
after pleading.
Lordship may be considered on mercy, not Lordship.
It's not agreeing. Why we insisted that if you give a consent, we can.
I can leave it to Your Lordship only. Yeah,
Your Lordship may kindly consider, Your Lordship may kindly consider. I will be rendered remediless, Your Lordship. After this, Your Lordship, other remedy, Your Lordship.
That's the mode of communication.
169, section 169, 1 subject
169.
D.
169.
169. Or is there.
All is there, Your Lordship. It has to be sent through post.
Any decision, order, summon, notice, or other communication under this act, any one of the following methods. And in all the methods, there is or is there. And Your Lordship, D is by making it available on common portal. And Your Lordship, section 146 says about common portal. And common portal, Your Lordship, as Your Lordship knows very well, it is GST law, Your Lordship. And in GST law, everything has to, we are bound by Your Lordship, everything has to be uploaded in the common portal. 146 is the common portal.
It also provides for communication through speed post, Your Lordship.
It's any of the mode, if it is there,
That's all, Your Lordship.
then we can't. Very different.
Lordship will be rendered remediless, Your Lordship.
What can be done?
Your Lordship,
I
without
tell you,
recording.
that is,
Lordship, like
if the
time
law,
bomb, just-
the law is ours, it has to be accepted as.
Lordship, and again, he's saying that in time bound manner, just 7 days time again, I will. comply and
After
send
knowing
it.
our view, we will not.
Lordship, no, not for that. Your Lordship.
This is unfair on
Your
your
Lordship,
part.
not time, I'm not seeking
No,
time
sir,
to
we
file.
are
I'm
not
seeking.
going, we are not going beyond this time. That's why we insisted on it. And if we give a consent, we can record a consent and do it. If it does not, then we are not going to set a precedence which is contrary to law. Otherwise, everybody will come after 5 years or 6 years or 7 years and say that my knowledge was not there. It's can't. If any of the following mode is given, then if one is exhausted, that's a. Okay. Yes. The party order passed by
Assistant Commissioner.
opposite party number 2. Who is this?
Your Assistant Commissioner of State.
As Assistant Commissioner of State for the period 2017-2018 under Section 73 of the OGST Act 2017. Together with Rule 142 OGST rule is challenged in the instant repetition on 2 counts. Firstly, that no reasonable opportunity of hearing was provided by the state authority. Secondly, the order was not communicated to the petitioner, and therefore the challenge seen before this court could not be made within a reasonable period of within the reasonable time. It is the show cause notice was issued upon the prisoner, which was duly replied to, and subsequently the authority did not find the reply to be satisfactory and passed an order. It is contended. It is contended by the counsel for the department that since the petitioner himself has admitted that no personal is required in such regard, the order of rejection cannot be impeached on such a score. Be that as it may, the submission advance before us relates to a passing of an ex parte order and the knowledge to have been imputed recently. Our attention is we invited the councils to Section 146 of the OGST Act 2017 postulates that the government, on a recommendation of a council, may notify the common goods and services tax electronic portal to facilitate the registration, the payment of tax, furnishing of a return, computation, and the settlement of the integrated tax and to carry out such other functions. As may be prescribed. Thus, the creation of a common portal, as envisaged under section 146 of the said Act, is to facilitate not only the uploading of the returns, the registration, but also the payment of tax, including the adjudication made by the competent authority and uploading of the order the aforesaid notion further be corroborated by section 169 of the said Act, providing the mode of communication of any decision, order, summons, notice, or other communications under the said Act. Stop. The language used in the said section leaves no ambiguity in our mind that the modes contemplated therein for communication of the decision order or the notice can be resorted to by the authorities first of the expression any one of the following unquote has to be understood in a pragmatic manner to mean that the different methods imbibe within the folds of the said section, any one of them, if exhausted by the authority, would be construed as a compliance provision. So any other meaning to be assigned and or ascribed to the expression any one of the following method would be against the legislative intent. One of the method is contemplated under section 169 for communication of a decision or the notice or the order is by on a common portal. It is not in dispute that this decision of the authority was uploaded on the common portal. And therefore, it cannot be said that that the authorities have not communicated the said order to the petitioner. Next one. It leads to another pertaining to a delay and laches attributable to the conduct of the petitioner in approaching this court. We are not unmindful of the proposition that there is no period of limitation provided under the Limitation Act in relation to an application under Article 226 and 227 of the Constitution. The apex court as well as the different high courts have imposed self-restraint upon themselves in exercising the discretion under Article 226 of the Constitution, if the approach is made belatedly and bereft of any reasonable explanation, the delay and laches attributable to the conduct of the litigant may disentitle him to get the relief. And the court may at times refuse to exercise such discretion vested upon them. The moment the order is uploaded on a common portal and it is inconceivable that there was no knowledge of the said order to the petitioner. The order was passed as far back as in the year 2023, and the challenge is made to the same in the instant writ petition filed in the year 2025. An explanation except that the said order was not within the knowledge of the petitioner. In view of the discussions made here in above, we are unable to accept the contention of the petitioner that the order was not communicated to. There is an apparent delay in approaching the court and refuse to exercise the discretion vested upon us, vested upon us in under Article 226 of the Constitution. Accordingly, the application is rejected. It dismissed. No order is.
May I pray something about it? Liberty may be given to file the appeal at Mr. Lordship.
But liberty is always with you.
But this order, how can Your Lordship, that delay the Supreme Court before Supreme Court, Your Lordship. And Your Lordship was against the Calcutta High Court also.
Your Lordship, actually, the opposite party number 3, I must say.
Before the delay because of administrative.
Item number 23.
Before going to the conclusion order, I would like to place some facts in not sir. The petitioner is a manufacturer.
Inconsistent name. Fire and water, how can they coexist?
My lord, they have written fire water. The name of the.
That's why I say, how can they coexist?
My lord, since 2011-12 excise year, this is the manufacturing unit licensed to produce, my lord, whiskey and rum. What happened, my lord, as per the conditions of the license and the statute governing the field, my lord, no manufacturing unit can they sell directly to the customer their products. They will sell through the OSBC, my lord, Orissa State Beverage Corporation Limited. Suppose, my lord, for a particular excise year, if any product remain unsold and it kept in the warehouse of either in the Orissa Beverage Corporation or warehouse at the manufacturing unit, data has to be destroyed within period of 6 months. And also the company manufacturer liable to pay the excise duty along with 10% fine. Lordship may see the provisions of the statute. Rule 55 of Orissa Excise Rule 2017. May I read, madam? Rule 55.
It is the
earlier disposal.
earlier disposal, my lord, the demand notice was because there was a levy of excise duty in excess.
What is it? London proof liquor.
That is the unit of a liquor, my lord. The bottle consists of what? That is 750 ml. That is known as LPM. Or should see the provision 55 of the Orissa Excise Rule 2017. May I read, my lord?
Just give us 1 minute.
CD 55(2).
Yes.
When an intoxicant kept in the premises of corporation warehouse or a licensed bonded warehouse is found to be deteriorated in quality by the officer in excise or superintendent, samples of the stock shall be drawn and sent for chemical examination for authorized laboratory to determine whether or not it is fit for human consumption. Then, my lord, this order relating to excise 23-25. The rule says they, if beyond 6 months, prior permission of the Commission, Excise Commission, all the stocks remaining in the warehouse of the manufacturing unit, that will be destroyed. I will have to pay the beer of the cost after chemical examination. Also, you may see clause C, Roman 3. After permission is accorded under subsection 1 or 2, the case may be the stocks shall be destroyed by the superintendent of excise in presence of executive magistrate to be nominated by the collector. And till date, the stock is still lying with me in my warehouse.
Is there any standard operating procedure for destruction of those intoxicants?
Because first chemical examination is required. Basing upon that, to declare this product.
Because there are certain goods which has a shelf life.
That is, I have given my, they have not destroyed. I was impelled to approve the commissioner, let's say Annex 2 says.
So according to you, those are being stacked in your premises?
That has to be also destroyed.
Yes.
I have to pay the excise duty with penalty.
True. Then what do you want? What is your grievance?
Now, my lord, instead of destroying the same, now they have imposed the penalty. In the earlier occasion, I approved this, your honorable court, that was excess levy of the excise duty. And that score, and it was also prior without any show cause, that was quashed. Now, you may see the previous order. 5. It starts from page 23. Particular page, the operating portion 25. 26, madam. Last paragraph. Mr. Beura, the conducting AGA, submits further the demand was made excess of 1 rupees per London proof liter. State will rectify the demand on the petitioner for the equal demand is satisfied and passed. Then
that was a concession which was made by them. That the demand was excess.
Then they impugned the lordship can come to impugn order Annex 6.
No, Rule 19 not provides for levy of any penalty.
Yes, penalty. I have to pay.
For operation of that rule, they have levied penalty.
Rule 99, my lord. Lordship 12. It is clear. I have to pay, my lord. But the manner they have fixed, because now they say there is a revised excise duty. That is the subject matter of 45 cases. Still cases pending.
Sir, tell us one thing. When you approached the
earlier,
at that point of time, the intoxicant liquors were already there.
With me,
you could have raised this issue of Section 55 non-compliance there in that petition itself.
Yes, but I have written.
But the court ultimately did not find that there is any infraction having done. The court simply found that there was an excess levy by them by rupee 1, and the court passed an order. So
Now-
now you had an opportunity to raise that point, having raised and then either decided consciously or not decided consciously.
Because
Will it not be treated to have been
because
closed
at
for
the-
all time to come?
at
Can
the
you
outset-
raise that demand
At
again?
the outset, the Law and Additional Government Act, they said, they have admitted there is a levy of 1 rupees extra.
You could have raised the.
I had,
Section 55.
earlier petition, I have taken all stands.
Will it not come under the purview of explanation 4 or 6 of section 11?
Yes. Everything I have taken
No,
stand.
no. Will it not come within the purview of explanation 4 or 6?
Now,
If you have raised a plea in an earlier round of the proceedings, and if the court disposed of that earlier round of proceeding and did not grant any relief thereupon, then why not it will be treated to have been decided impliedly. And then the bar of section 11 will come res judicata. So,
again,
how can you raise this
now,
point now? In this
another point, my lord. Lordship, the impugn note of page 29.
Yes.
The new point come up.
Oh, what is that?
That the middle portion, my lord, third paragraph.
Yes.
Whereas the petitioner has misinterpreted the applicability of duty of rupees 692.82 per LPL by letter number so and so dated. This is very important. 23 March 2024. But the said duty amount has revised to 693.20 per LPL is to be applicable for 23-24 so and so dated. 9524 is the only 30 rupees, 38 paisa is the difference. That the excise
38 paisa is different.
Only difference. Lordship may see annexure 4.
No, not rupees 1.
Not rupee 1.
But they have admitted
They are
rupees
happy 1 rupees. Now it is a 38.
Only to that extent.
That extent, my lord. What happened? This particular issue is now the subject matter of 45 rate applications. It still has, we are voting for decision because same point was raised extra, there is a revised excise duty. Now matter is pending before number of cases before this honorable court, but interim order has been granted. Instead, in number of cases has not identified counter. So, my lord, excise duty fixed for a particular year. 9th May is it relates to another excise.
It does not relate to this. This is the MGQ.
MGQ, but same excise duty and same fine.
The only thing is that is what troubles me, subject to clarification from you. If in an earlier writ petition, you admitted that there was an excess of 1 rupee, can an authority go beyond that and say that no, there is no excess of 1 rupee, it is only 0.38 paisa?
The authorities on re-examination of the matter.
Can you do it?
Your Lordship,
I'm just asking, if the court has examined and the court has said that there is an excess of 1, will it, because that is the order of, come to the order of the.
But the order of the court, your Lordship, kindly see, the honorable court has not given a finding that it is
That
excess.
is what I, please come to that order.
Yes, the order is at page 20. It is at page 25. 25.
Yes. If you come,
yes,
please this. Your counterpart was there.
Yes.
He says
Para
that
2
appears on behalf of the state and draws attention to the letter dated such and such written by the petitioner.
Yes.
To the superintendent.
Yes.
And then says long time the period is there, others money such and such. He submits that the demand was made by excess of rupees 1 per LPL. Then says state will raise rectified demand on the petitioner, means -1. Then the improved order was set aside. Can you now take a rebound and say no, not 1.38 paisa? That's the only thing which troubles me.
Now, my lord, so far as rectification is concerned,
this was accepted.
Now, my lord, so far as
Then we'll have to ask for a modification of the order, otherwise you can't.
But so far as rectification of the order, your Lordship may kindly see the impugned order. Lordship may
You
kindly.
have said 38 paisa is not 1 rupee That is what you said. Can you do it after this finding of the court?
Now, my lord, this order is appellable. The order passed by the collector.
Alternative remedy is not an absolute bar. If
Not
we
an
find
absolute
a
bar, but that
manifest
is open to me.
injustice, if we find manifest injustice apparent on the record,
Yes.
then the red court can definitely interfere. There's no difficulty because it was your stand. You said that yes, it was a 1 rupee excess.
Yes.
If you have said whether it can go above the order of the court, can he go and say that this order of the court is not correct?
But
We'll have
I'll
to
have
get up
to
one.
obtain instruction and file an affidavit to that.
What affidavit? It is an open and shut case, sir.
So that
Pure
I-
question of law. If in an earlier round of litigation, if the court has said that there was a 1 rupee access charged by you or demanded by you, and which is accepted by the then on that basis the entire order was passed, and the direction was to fix or recalculate it. State will raise rectified demand on petitioner, meaning thereby -1. Can an authority say 1 rupee is wrong, 38 paisa is correct?
Whether the concession made by the state council
Before
before the court
Sir,
was purely based on
correct.
his own views, or it is based on the instructions received from the authority.
There is a distinction
Yes.
between a concession made before the court. If it is a concession on law, that concession is not binding. If it is a concession on fact, that remains binding. I've not been able to say that this concession is, you have to approach the same judge and ask for a rectification. That there was no concession.
I understand, but
that
this
is
matter
clear
has
as
come for the
face.
first time, so let me take
I can
instruction.
supplement many judgments on.
Now that they have
that. Concession on fact.
There
and
cannot be
concession on
concession
law.
against law, but there can
Law
be
definitely not binding,
Yes.
but fact.
fact. Yes.
That if you say that this concession was without any instruction, then you'll have to ask for a rectification and recall of the order. or
Recall of the order.
modification of the
So
order.
instead of that, how they have passed this final order?
Whether the authority
Yes.
can go. Can go beyond the order of the court, then
The matter has come
then
for
there
the
will
first
be a
time. I'll have
complete
to
anarchy,
take
sir.
instruction.
There will be a complete anarchy. The order of the court will not be respected. Will not be respected. The authority, as per their own whims, they will proceed. No, sir. The law is settled on this.
Then you also
Settled on this.
exact me which time so that I can obtain instruction. on
Take your
what-
time, but I don't think so that anything can be improved in this regard.
Yes.
We are not with him so far as section 55 is concerned. To
Yes.
be very, very fair. We are not with him on section 55. That door is closed for him.
Only the concession made by this.
One. Is there any standard operating procedure for the disposal or destruction of those?
Only when I suppose
There is any rule, regulation or a guideline which is
then
issued?
only under the 55, the superintendent will obtain permission from the
Sir, that's the procedure
Procedure.
for obtaining, but for destruction, house to be destroyed, is there any
That-
mechanism?
their manual perhaps.
I just want,
I'll also apprise the lords on that.
like you know the judgment of the apex court in Mohanlal's case, so far as the IDPS
Yes,
are
yes, yes.
concerned. The Supreme Court has said how the disposal, the policy has to be adopted by this
Adopted for
government
disposal.
for disposal of those
The manner of disposal.
contracts, how to dispose of. Similarly, here, there should be a policy. There
Yes.
should be some guideline.
It must be in place. So
Yes, huh.
No,
I'll
how to,
produce-
how to
Yes, my lord.
secure the disposal.
My lord.
We are pouring in a sewage line will do. or?
It was they are doing in earlier page.
Once it's found unsuitable for human consumption, then it has to be done through a SOP.
They are pouring it in the sea.
Storage in Konika Church, the excise officer there in my area, where office shifted, they poured the entire matter in the inside the storage.
This is different.
The seized
There must
matter.
be a standard policy, uniform
Yes.
policy.
I'll produce that policy in the next time.
I'm just asking whether there is a policy for disposal or destruction.
Yes, it is there.
It's for human consumption. So
Yes, it's there.
definitely
Not
very
Yes.
insecure
Yes,
and very dangerous.
It's there.
there is a policy, but I'll produce it.
Because
You just wanted.
the ethyl alcohols are turned to methyl alcohol. That is poisonous. That ethyl alcohol is turned by efflux of time to methyl alcohol. That is very poisonous. So, my lord, by virtue of this impugnal, now they have not renewed my license. 70% out of that job, and every day state is losing 6 lakhs revenue because manufacturing stopped.
Sir, how much time you require to take this?
Weeks time. Weeks time.
So can we fix it on 16 or 17?
Well, on 70.
Mr. Das for the petitioner. Mr. S. Das can be. Next, Mr. S. Das submits to get instructions on the concession earlier rendered on the part of the state as reflected by the order dated 15 January 2025, passed in WPC number 1096 of 2025 regarding excess demand of ₹1 for LPL. List on 23rd April. Stop. Mr. Das is to take instruction about the existence of any SOP or
Disposal of
SOP regarding disposal of the intoxicated
expired products.
Intoxicant. This is intoxicant not fit for human consumption.
intoxicant IMFL.
Deteriorated in quality. That is the statutory.
Deteriorated and sedimentation is there.
Not fit for human consumption.
Not fit for human consumption.
Not
Intoxicated IMFL that has deteriorated in a flux of time. Stop.
and become not fit for.
And not and become unfit for human consumption.
I have tried. Not to take because the unit has not renewed. 60% are out of job and state is losing
Then
impetus
what interim direction we can pass?
on IA, not that stay of that impugnal, so that it can be renewed because state will get another 1.5 crore revenue once it is renewed.
That order was passed when
At 28/3, 1st April it was required to be renewed. They are not renewed.
what do you say?
We have not renewed because of this non-fulfillment of the demand. Now, if your lordship will examine the matter on
Subject to
17.
fulfill, you renew their license.
That's it. They do not allow my lord.
You consider.
Funny part.
We'll say
I am ready to pay the license fee.
But subject to fulfillment, that would be against the provisions of the statute. So what I pray, let the matter be heard.
We are keeping this on 70. If you have waited for such a long
Yes.
time, wait for another 7
At
days.
least not to take any coercive action.
Whatever they will not, they have already demanded, no difficulty, it's coming on 17. 17. 17.
Item number 24.
Please, my lord. My lord, inadvertently, my lord, we have not filed one document to affidavit, my lord, and filed. My lord, what has happened in this case? Petitioner is into film production. The assessment took place, my lord. In that assessment, he could not participate because his manager was of ill health, my lord, and he suddenly passed away. So he couldn't participate in the assessment proceeding. So ex parte order was passed against him. Thereafter, my lord, he filed an appeal and he took the plea that because of his sudden passing away of his manager, he could not participate in the proceeding. So he should be given a chance to protect his interest before the assessment authority. That is my only prayer, no, because I am not entering into the lyrics.
Where is the order of the
order is that page.
connection?
Next one.
Is the order passed in an appeal?
Yes, my lord. This order was passed in an appeal. In the assessment order, my lord, I have given the affidavit. In the affidavit, the assessment order is there.
Demand is of which amount?
My lord, demand is of the 2017 and 18.
So what is the amount of demand?
It is 1,62,000, my lord.
You mentioned 20,000?
No, my lord. It is 1 lakh.
Tax and
penalty.
In the 1 lakh
Yes,
is the tax amount, and 20,000 and 10,000 and 20,000 is a penalty.
The case of the petitioner is that they have paid it, but there is a calculation variations, my lord, which he wants to bring it to the assessing authority. If given one chance, my lord, before the assessing authority will clarify all those things, because only his manager was suddenly passed away.
Yes, what you say?
Order has only merged with the appellate order. So appeal order has already been passed. So far it's merged with the order.
He's talking about the appeal order.
Yes.
That he has gone to the appellate authority.
Yes.
Because the assessment order was passed ex parte. And he says that I could not appear because the manager who was really looking after the entire thing passed away.
No, in appeal he is participated. His appeal is participated.
It's an amount of
challenge is made to an ex parte order before the appellate order.
Yes.
He has flagged an issue that why I cannot appear before the assessing is the reason.
Yes.
So there is no difficulty that the appellate authority has passed order in presence of the petitioner.
Yes.
But he has failed to take into account the genuinity of the grounds which he has assigned.
No, he has not passed. Lots of pleased to see the order. He has elaborately discussed everything so far as discrepancy on the 3A and 2A. So discrepancy is the fact remember there is some discrepancy about the filing of returns. In the 3A and 2A, there is a discrepancy. As per 16.4, the demand has been raised. And ex parte order is passed in the order.
Has he considered on merit?
Yes, sir. Yes,
he has considered the case on merit.
Page 15.
He has considered the case on merit.
Then what remains?
No,
Document where
1 minute. Assailing the order on the ground that I could not participate before the assessing authority.
The authority gave you an opportunity to participate.
But my lord,
and all the documents which you intend to rely before the assessing officer was also taken into consideration by the appellate authority.
My lord, that is my lord. Before the assessing authority is the authority, my lord, because when I go,
you are
He will not wait 10%, you wait for the.
What are you doing? You are a clean product.
He report 10%, wait for the.
Amount is very negative.
Part of the travel amendment. So you
Only want to get an opportunity.
10%.
Yes.
Happy with the 10%.
Deposit and wait for the tribunal function.
Yes.
My lord, what I submit, my lord, if I given a chance before the assessing authority, I can clear this because I have already paid this tax.
Then there will be a difficulty.
My lord, whatever my lord feels.
Because if the appellate authority, which is the last fact-finding authority,
Extended
he has considered the case on merit.
My lord, after this is my lord, after this there is an authority.
It is
My lord.
better to have that benefit of 10% than
Deposit wait for the tribunal. Yes, my lord, but the tribunal is no.
It's not yet
Yes, my lord, I'm happy.
He is coming for you.
Definitely, my lord.
And for this paltry sum of 1,80,000, you are fighting.
No, my lord, I'm not fighting on that because they are in
a.
He has paid the tax, not examine, he has paid the tax, but it's not in that period. That is the issue. In that period, there is no exemption was there. So it can be adjudicated because it's in this forum, it cannot be.
Where is the order?
My lord, I don't have an order.
Same order that 10%.
10% now.
10% that.
Yes, sir. Good tribunal is not there.
Yes.
Same order. We have passed.
Yes. And he has also, delay has already been condoned. Delay also, the appellate authority is condoned.
The name. He has
Jwalamukhi.
Jwalamukhi. Jwalamukhi.
That's
Item number 25.
Yes, may please. Who number of mine and doctor's mine.
Notice blah blah. 15th May. On the question of limitation and admission.
Item 27.
Delay is delay is of 37 days.
Have you served the other side?
First time it has.
Same notice, 15th May.
28.
Delay of 123 days, notice has to be.
IA number 6 it is disposed of. Granting the payer dispensing the certificate copy. Blah blah. Then IA number 6779 and WA substances. Should notice on the question of limitation as well as admission. 16 April. In this case, I have filed the caveat with some manner. I have served the notice.
Why you have not served the caveat on?
The name of the caveator may be indicated in the list. Item 28, 2569. Submitted by Mr.
Yes, sir. The copy. Yes, fine.
But that is not affected upon the. That's not coming in this month. My name is not.
When you lost the caveat and when the appeal was.
And prior to filing of the appeal in the month of July.
It is expired from the date of filing.
I don't know, my lord.
90 days did not expire.
18 September. It is when
the appeal is filed.
The appeal was filed 18/9/24, man.
18/9.
18/9. 18/9/24.
18. 18. And when you lost the caveat?
I have filed in the month of July, last week of July. Exactly, I have not kept the file today.
So it was your test, sir.
And indicate the name of the caveator as submitted by Mr. T. Pandan and counsel. That he has filed the caveat on behalf of OP number. Respondent. On behalf of the respondent. Next.
Item 29.
Same issue notice on the question of limitation.
State is the party.
Item 30.
Since petition dispensing with filing of the certified copy, that but that application has become infructuous. That IA application.
What the certified copy?
Yes, it's already filed. It is there on record.
Note 32.
The appellant was in the early 70s.
He's got the copy.
Say they're not it.
Item note 33.
Just in short, the writ petitioner approached the single bench to quash the suspension order and the initiation of the disciplinary action on the ground that the authority which has issued it did not have the authority. Actually, it was supposed to be done by the governing body, but the secretary only did it. In fact, this very college does not have a governing body which is required under the 1991 statute. So what the court did allowed my prayer, but then there was an argument for the other side that he was, by the time he was the principal there. So it said, if you
Sees the charge of the principal officiating.
yes, and but he was regularly promoted from lecturer to vice principal.
True.
So that you have taken the benefit of being promoted. So therefore you cannot come and say the same thing. But the governing body was not there from the day one till date. And on that ground, even though the repetition is allowed, but the single bench said that no, you will go back to your place of lecturer. And at the threshold, I mean, when I was
That's
supposed
at
to
the feeder post.
yes. May I just read that portion, Your Lordship? 8.2.
Where is the which is the annexure?
Annexure 1, it starts at page 19, 19. And relevant portion would be 23, if I can place that. 8.1. 8 actually.
So the order of suspension was quashed.
Squashed.
So quashed.
Yes, the problem is the court directed that I should join as a lecturer, not in my original post.
Oh.
May I clarify, ma'am?
So so therefore.
The order of suspension was issued on you when you were a principal officiating.
Yes.
Yes. That's
So,
right.
no, I was principal officiating. Prior to that, I was promoted as vice principal. And while I was holding the position of vice principal, I was also officiating as principal.
No.
So at best, I should have gone back to the post.
Vice principal.
The logic that they, which flows from the judgment is that did not have a governing body.
No, I understand.
And so therefore, all the benefits will also go. I mean, so that was
Because the
not my-
promotion was also done through a governing body
Yes.
or through them.
But that's the case for the entire college. I mean, if the logic would extend to there, the entire college has to face that. But that's not where I'm taking the argument. That's not my prayer. That's not my pleading. I mean, and the opposite party cannot take the benefit of its own wrongdoing. It's on the society to send that and comply with the 1991 rules and regulations, which require that you should have a governing body.
Petitioner was appointed as a lecturer, he was appointed in a college which requires under 1991 rules a governing body. Governing body has got the power either to give promotion or to take any disciplinary action against them. He got appointment as a lecturer, subsequently was promoted to the post of senior lecturer. Thereafter,
vice principal, thereafter principal in charge. Now, my lord, against the petitioner, initially the order of suspension was there, thereafter proceeding was initiated. Those proceeding and suspension order having been issued by a person, secretary of the governing body, that was challenged by the petitioner before the on-reaching plan, saying that he doesn't have the authority to pass any order.
Can a court enlarge the scope of the writ when the challenge was only on the order of suspension?
I can understand that.
Can it go beyond the scope of the writ?
That I understand. One who doesn't have the power to punish, he doesn't have any power to do.
No, I'm on that. The petitioner came and challenges the order of suspension.
There is no
on the ground that the authority who issued the order of suspension is incompetent and have no jurisdiction to pass such an order. The court must confine on that whether it can or it cannot. But can a court fall back and then say that even your promotions which have been granted falls on the basis thereof, means enlarging the scope where he has not challenged that? Can it be done? I'm just asking. You can initiate a proceeding again and then say that these promotions are bad. You can do it.
Only proceeding can be initiated after constitution of the governing body. Because that cannot be done.
What judgment?
Just judgment that even though CPC strictly doesn't have right to read petitions, but
the principles akin to the several provisions. So what for?
Yes, that's the para 30 of this judgment.
No, what for?
That the court to confine.
Not to go beyond the range of such.
And just place 30.
What is the cost title? What is the cost title of the judgment?
Lordships, that's Bharat Amritlal Kothari versus Doshab Khan and Samad Khan Singhi. I'll just read para 30 of it.
Yes.
Though the provisions of the code are not made applicable to the proceedings under 226 of the Constitution, the general principles made in the CPC shall apply even to writ petitions. It is therefore incumbent on the petitioner to claim all reliefs he seeks from the court. Normally, the court will grant only those reliefs specifically prayed for the petitioner, by the petitioner. So the court has a very wide discretion in granting relief. The court cannot ignore keeping aside the norms of the principle governing grant of relief and grant relief not prayed for by the petitioner. So I know it's not really strictly applicable, but if we go
Mutatis mutandis applies.
Yeah, if we go by that, that's
our High Court rule does not speak of application of principles of CPC.
It says, it talks about.
Then why are you referring?
That's what I'm saying. This judgment is not effective place.
No, she's referring that the reliefs which are not claimed cannot be granted.
That I understand. I said that.
So what do you say? That how can a single
development is my lord in the meantime? Governing body is constituted.
Analogy was slightly reversely.
In the meantime, my lord, governing body of that college has been constituted. The lord will allow
post facto approval of everything.
It is okay. There are lots of kinds.
But reversion to a feeder post is the big issue. How can it be done? This cannot be done.
No, Mr. A.R. Das standing
I was appearing for the society which has ceased to have any function so far as the institution is concerned because the governing body has already been formed. Since October
approved and constituted
It's
and
an
approved.
aeronautic degree college.
Yes.
Now it is.
It is a degree college.
Degree college. Degree college.
The decision taking authority would be the present governing body so far as he is concerned.
No, the analogy applied by the learned single judge. That since he has he is challenging the power of the authority in suspending him, then on what basis he has, why not he promotions granted by the same authority shall not be rewarded?
That is the analogy applied.
It becomes a counterproductive to him. Challenging on that point becomes counterproductive.
Now,
That's what also.
salary of
that's
1,000 rupees. He's gone back to the salary of
Submission of the
2,000.
petitioner has been reflected in the judgment that had I known the judgment, my promotion will be, I will head back to my original post.
I would not have pursued.
I would have withdrawn the
No, that's a very genuine, anybody, any human being will definitely stand by that side. So that portion, order of suspension has gone. Now the governing body is there. You take steps against them. Whatever the governing body is in place, but cannot be done in this way. Yes. Yes. A piquant situations arose to the petitioner while disposing of a writ petition filed by him or her, filed by him, assailing an order of suspension issued by the society who no. Issued by a society. Issued by the society, the comma.
Respondent number 3.
Respondent number 3, comma, in contemplation to initiation of the disciplinary proceeding. A specific plea was taken by the appellant that the society has no jurisdiction and or competence either to initiate any disciplinary proceeding or to pass an order of suspension as such powers have been, such power is vested upon the governing body of the college in terms of what is this OE?
Education.
Education within bracket ERMPA.
Establishment, recognition and management of private colleges.
Schools rules 1991 read with the OE the same amendment rules 2001 and amendment rules don't write it under this such and such as amended from time to time. Such issue has not been disputed for the simple reason that the governing body is vested with the power to initiate disciplinary proceeding as well as to pass orders in due management and administration of a college. Full stop. The single bench accepted the contention of the appellant and held that this order of suspension can only be issued by the governing body constituted under the aforesaid rules, which has a statutory flavors, and consequently passed a further order reverting the petitioner to the feeder post as all the promotional orders were issued by the society and not by the governing body. The seminal point involved in the instant appeal is whether the writ court can go beyond the reliefs claimed in the writ petition and pass an order neither prayed for nor contemplated by the litigant. Stop. In support of the aforesaid point, the reliance is placed upon a judgment of the apex court in Bharat Amrit Lal Kothari and another versus Doshu Khan, Samad Khan, Sindhi, and others, reported in 2010, Volume 1, SCC 234, wherein it is held that though all the provisions of the Code of Procedure is not applicable to a writ proceeding in stricto sensu, but the principles akin and or emanating therefrom is applicable to a writ proceedings. It is no longer res integra that the principles emanating from the Code of Procedure would mutatis mutandis applies to a writ proceedings, which would further be corroborated by the fact that the writ rules framed by the High Court, it is there, contemplates the provisions of the Code of Procedure to apply in a writ proceedings as far as made practicable. The importance of the pleading and the release in an adversarial system of adjudication is not unknown. The court cannot make out a new case, nor could travel beyond the peripheral of the pleadings as well as the reliefs claimed therein, and should confine within the four corners of the pleadings and the reliefs. The apex court in Bharat Amrit Lal Kothari and another Supra in health, you have quoted wrong. Actually, it should be paragraph 29, the first sentence. The approach of the High Court in granting relief not prayed for cannot be approved by this court. This is the main line. And you quote paragraph 30. Quote paragraph 29 and 30 of the said judgment. Very important. Even paragraph, yes, 34 is very important. 29 to 35, you just quote up to 30. What is this? 33. Up to 33. In view of the law enunciated in the above report, it is beyond cable of doubt that the court cannot venture to travel beyond the circumference of the pleadings and the reliefs claimed by the litigant, except in an exceptional and extraordinary circumstances where the reliefs initially claimed becomes inappropriate by passage of time or because of the subsequent events during the pendency of the litigation, and the necessity to extend the reliefs by molding the same. Look, in the instant case, the relief claimed by the petitioner was restricted to the illegality in passing an order of suspension, having no nexus to the promotion having granted in course of the service rendered by the petitioner, and therefore the portion of the order by which the petitioner is relegated back to the feeder post does not appear to be legally sound. Accordingly, the portion of the order by which the petitioner has been reverted to the post of a lecturer is hereby set aside. The remaining portion of the order is unaltered. Stop. It has been brought to our notice in course of the hearing that the governing body has already been constituted and have taken charge of the college. Stop. It is open to the governing body to take a conscious decision and to take actions as permissible in law.
May I just small correction, Your Lordship, we had challenged both suspension and also the initiation. The charge memo was also there, so if that is reflected.
No, I have not said so anything about it. I just simply said that the order by which your promotion has gone, that is we set aside. Remaining, I have not altered. We have not altered. Order of suspension.
No, but
and the order of suspension wherever I've used, and the consequent action that will survive. Disposed of. Cannot.
Item 40.
Similar kind of retribution.
Yeah, well, that's page 39 if your lordship takes.
What it says.
That's a gradation less ballots. Your lordship sees.
Page 39 is which annexure?
This is annexure 9. Annexure.
Page 39.
39. 36 it begins. Invite your lordship attention to page.
Yes.
39 your lordship sees from the top. Fourth entry. Assistant Director MIS.
No. What entry?
Assistant Director, Group B officer.
Yes.
Fourth serial is Assistant Director MIS.
Yes.
The petitioner, Zapal and Malaks, he was discharging his duties in this position, being promoted there.
Okay.
At that point of time, by the impugned order, he was reverted to the post of programmer, category 2, serial number 4.
Programmer means category 2.
Category
yes, 2. Yes.
Serial number 4.
4.
Roman 4. Programmer. This he essayed before this honorable court.
She was appointed at what post initially?
Appointed at programmer cum training officer, category 1, serial 1.
Category 1, serial 1. And then from there that is the first posting. That is the first posting.
No, she was promoted. She was promoted.
What was her initial appointment?
Programmer cum training officer.
Initially, when she started the journey of her service.
Yes, madam.
Which post?
That was programmer.
Programmer come training officer. That is Group C, Category 1, Serial number 1.
She started with that.
Yes, he started with that.
Oh, yes, sorry. And then from here,
he was promoted
to the Assistant Director, MIS.
Yes, sir.
And reverted back to this, now the programmer, Category 2.
Yes. This was challenged before this Honorable High Court in a writ petition. The Honorable High Court allowed the writ petition, quashed that order, but has now allowed me to continue as a programmer cum training officer, ignoring the promotion that I have benefited in the meantime.
Right.
That your lordships will get at page 53. The judgment of the learned single judge, it begins at page 45.
What was the reason for setting aside?
Setting aside that the grounds on which, in fact, it was alleged that one of the certificates which I had produced was obtained from a fake university.
Fake university or a fake certificate from a genuine university?
No, fake university. What happened was the required qualification was a degree engineer. I was a degree engineer from a recognized university. Over and above that, I had obtained a degree for Master of Computer Application, MCA, from another university. Now, at the time I had obtained the degree, there was no difficulty. Subsequently, it was held that the university is fake.
Because of the judgment of the Supreme Court?
Yes, ma'am. Yes, ma'am. And as a result,
several universities which do not have anything.
So, Malaj, MCA is not a requirement for the position at all.
But the eligibility criteria is the Bachelor in Engineering.
It does not come within the eligibility criteria. MCA does not come within the eligibility.
Bachelor in Degree Engineering is the eligibility criteria.
Was the engineering was the
and this was found to be fake.
This was found to be fake in 2014.
Whatever. The Fraud Unravels All Act.
Yes. Okay.
Yes.
Well, I obtained the degree in 2004, and the university was declared to be fake in 2016 by the UPS. 12 years.
No, you mean to say that prior to 2012, the university was genuine?
It was declared to be a fake university in 2016,
That's right.
so it became fake for all times to come.
All times to come and
And prior also. That was the MCA degree. I don't require MCA degree for my.
No. Please tell me the fact.
Yes, sir.
Is it the bachelor degree of engineering which was obtained by you from a university which was declared as a fake university?
No.
Or it is an MCA degree?
MCA degree
which you obtained from a university or a college which has been declared to be a fake university?
The MCA degree. The MCA, there is no.
And what was the eligibility criterion for
Bachelor
this
of
post of
Bachelor of
programmer?
Engineering. Bachelor of Engineering.
Correct. So that was there, no difficulty.
No difficulty.
the promotional post of this, what was the eligibility criteria for assistant director?
Same thing. Bachelor of Engineering.
Not MCA.
No, MCA was not at all a prerequisite.
Are you sure?
Absolutely.
Then
Subsequently, what has happened?
Where is the difficulty then?
Your Lordship may kindly see Annexure 6 appended to the petition at page 25.
If this is correct, then I don't think so there is any difficulty.
Annexure 6 at page 25.
Annexure
6
Yes.
at page 25.
Yes.
State Project Director OPEPA writes to the petitioner
Yes.
seeking explanation. With reference to the subject cited above, I have to say that during verification of the certificate by the committee, pursuant to OSIPA number so and so, the following disparities have been found at the committee. Although as the qualification laid down under the staff and pay structure of SSA, item 9 of the proceeding, the 15th executive meeting held on 21/2004, the requisite qualification for the post of assistant directors, that is, previously it was known as system analyst, is degree in computer engineering with knowledge of management of information system. But at the time of verification, it was observed by the committee that you have submitted the certificate of degree in electrical engineering.
That's what we are asking. That is what we are asking.
Degree in electrical engineering from Institution of Engineering India MCA from Navabharat Shiksha Parishad Orissa, which has been declared as fake university.
So your bachelor
degree goes.
That bachelor degree. Once again, I am placing that very sentence. The requisite qualification for the post of assistant director or system analyst is degree in computer engineering with knowledge of management of information system. But at the time of verification, it was observed by the committee that you have submitted the certificate of degree in electrical engineering
from an institute of engineering.
Yes, MCA from Navabharat Shiksha Parishad.
MCA is different.
No.
Comma MCA. Then
Comma. Then MCA from Navabharat Shiksha Parishad, Odisha. Comma. There is a comma. He is correct. After this India, you will find there is a comma.
This was from Sambalpur
That means
University. That is
MCA
different.
from Navabharat such and such from Sambalpur University. And also you have simultaneously acquired PGDCA and electrical engineering qualification in the year 1992. Further, it is observed by the committee that no experience certificate as stipulated for engagement of a program such and such. Your initial engagement has been furnished by you during verification. It has been observed that one public notice regarding the fake universities have been issued Vides such and such on 16 under the signature of a secretary, wherein the Navabharat Shiksha Parishad is declared as a fake.
Yes.
That means MCA degree goes.
Yes.
MCA degree goes.
Would your Lordship be kind of...
Because this is in terms of the order of the Supreme Court.
Yes, that's correct. Next page, 26.
Yes.
Next page, further, your Lordship, page 26. Further, you have not submitted any certificate in support of qualification of degree in computer engineering required for the post of assistant director, system analyst, and 3 years experience required for the post of programmer from training office, against which your initial engagement has been made, but submitted one MCA certificate from Navabharat. So he has not submitted the certificate pertaining to
There
qualification
used to
degree
be
in
no
computer engineering.
degree in computer engineering
That is
prior to 2004. Computer engineering degree was introduced for the, previously it was only degree in engineering, within bracket electrical. Now there was a specialist field post 2004, which provided for a degree in computer engineering also. Prior to that, it was not there. I have the notification, but I have the notification. Previously, it was Bachelor of Engineering. Now they have. I'll show you.
MCA qualification is also required. That's what transpires
For assistant director.
That's what transpires from this document, page 33.
33.
Third paragraph will be relevant. Whereas the minister represented the FPD OPEPA for the post of system analyst in OPEPA have been claimed to have the requisite qualification in MCA as required for the board as per decision of 15th.
No, that is the system analyst.
System analyst was subsequently redesignated as assistant director.
He was assistant director. Yes, sir, there is difficulty. That has to go. Sorry, you'll have to go. And the single bench has rightly reverted you to.
No, sir. I showed you, Your Lordship, the qualification.
Because what was playing in my mind was that if they have put you to a programmer, the post which you never held.
Never held.
Then there is a judgment of a Supreme Court which says that you cannot impose a punishment of reduction in rank, which you never held.
No, that has been corrected by the.
That is what is correct. So.
No, I'll satisfy Your Lordship.
Programmer.
The required
qualification MCA is required for this.
No, it is not, my lord. What is required is degree in computer engineering now and PGDCA. PGDCA I already have.
No, at page 35, it is at page 30, system analyst at page 33. It is equivalent to the assistant director. It says that the requisite qualification of MCA. No, requisite.
No, having claimed the requisite, that I don't.
But now, if you do not have MCA, then you not.
It is not there, my lord. The document is here. It's PGDCA, not MCA. And I have a PGDCA.
At page.
I know, I have seen that. I've seen that. Your lordship, I call it day after tomorrow. Just give me I'll get that document which reflects what the qualification is required. Previously, what it was when I joined. Subsequently, computer engineering, bachelor's degree in computer.
You can show us that at the time of your promotion, what was the rules or what was the qualification which was prevalent? And if it does not require an MCA, subsequent change of the educational qualification is not different coming your way.
But I'll produce those two documents at the time of my joining or at the time of my promotion. Next week, Your Lordship. Any day.
Next.
Contractual and Senior Counsel for the appellant. 6 time to satisfy the scope regarding the eligibility conditions for appointment to
the post of system analyst.
For appointment to the post of
system analyst was redesignated as assistant.
To the post of system analyst. Redesignated as assistant director.
Within bracket MIS.
Bracket MIS.
Okay.
List on 15th or 22nd.
Let me 22nd.
16, 22nd.
Item number 41. Item 46.
Annexure 6, page 25. Is in here, my lord. My case was rejected on the ground. I have not submitted the document in time.
Yes, only thing is that the timeline was given by this court in an earlier writ petition. He filed it out of that.
No, I have yes, here they have
exceeds the stipulated timeline set forth by the court?
They have rejected on that ground.
That is what I'm saying.
Yes.
So you have filed it after that.
Now, before that, I have filed it.
Where do
Yes.
I?
Yeah, Lord's, may I draw my Lord's notice to
Says that
order of this honorable court first file. Lord's, may turn to page 21. Para, may I draw my Lord's notice to para 8.
yes.
Earlier I have approved, my Lords have direct in some
Yes. The direction to inspect your institution within a week.
well,
And
it submits the required, if it submits the required
within 3 days means the inspection will be done if you supply the documents within 3 days.
if not submitted, here Lords, there is a bracket, if not already submitted.
Correct.
I have submitted earlier, prior to this order.
So is it admitted by them?
Yes, in their counter they have said so.
My lord, let me submit.
Let,
Initially, the petition was filed because he was supposed to clear the deficiencies within 14 days. That was not been done. That's why.
So that is, we are not concerned with
Yes.
this. But he says that I have already filed the document which are required.
Yes.
The court says that if those documents are all
if not submitted,
already filed, you have to go and make an inspection. And then take an independent decision. If those documents are there, make an inspection. They cannot come forward and say that no, further documents are required to be relied upon. They will not. Whatever they have filed it on the basis thereof, make an inspection and take a decision.
Lord, they have, but our decision.
in court,
NOC
my
for-
Lords may see for a moment this
24,
affidavit.
You have already, they have already filed the documents.
Yes, your Lords may see the affidavit in earlier case, they have filed their counter stating inter alia, we have complied on 30/6/2025.
We have not taken into consideration because that was delayed.
Yes.
They have filed the case.
That was?
Because the provision, the notification was any deficiencies found to be within 14 days, that is to be complied.
No, Mr. Mandi. The earlier direction of the court was to go and inspect the documents, inspect the institution. And they will file the documents if not filed
No, my lord.
within a period of 3
No,
days.
my lord.
If it is their case that they have already filed the documents, then it is up to you to go.
I will pardon to mention, clarify. Initially, the petition was filed for issuance of NOC. While filing for NOC, documents have to be produced for inspection. If the deficiencies are there, they have to rectify the deficiencies within 14 days. That letter was gone to the institution for the supplying of the documents within 14 days. That was not been done. In so many cases, the honorable court has found that that is not filed in time. Will not enter.
Sir, the question is that when the last order was passed.
Yes, ma'am.
And a period was extended, say by 3 days to submit the documents. You cannot fall back on the earlier that it ought to have been filed within 14 days. They did not file it within 14 days. You can't because the time was extended. With the rider that if they have already filed means that would be deemed to have been filed within that extended period of 3 days. And then you make an inspection and take a decision.
They have not met within 3 days, my lord.
No, they say that I have already filed it, which you treat as a filing beyond 14 days, which you treated. If the court has extended that within 3 days you can file, that means that particular defense, that it was beyond 14 days was really ruled out against you.
I know that's there.
So
If
you
you have
consider
not-
on that which he says that I have already submitted all the documents. You make an inspection, do whatever, take a decision. Why you are not taking a decision, sir?
My lord, the
Has to be construed in this way.
my lord, the NOC time is over for 25-26.
We are not on that part. You make an inspection and decide accordingly.
We will make an inspection.
Wait.
Yes, my lord. Would make an inspection. And in the meantime, they have inspected the institute and they have shown certain deficiencies and we have complied that. Thereafter, they have rejected it.
What reject? They have not done the inspection as per the.
After this order, they have not inspected.
That is the.
No, they have not. They have rejected it, but because I have not filed a document.
Who will make an inspection?
Mr. Kuntia, not Mr. Kuntia for the petitioner, Mr. Manti for OP number 2 and 3. 2 and 3.
Yes.
Stop. The petitioner's institution had earlier approached this court in WPC number 18624 of 2024, wherein a direction was issued to OP number 2 to inspect the petitioner's institution within a week if the requisite documents have already been submitted within 3 days in case it were not submitted, and to consider its case for grant of NOC/renewal of NOC based on the inspection report and other materials, and in accordance with law. Stop. After passing of said order by this court in the aforesaid writ petition, the chairman of Orissa Nursing, OP number 3 now OP number kya
2 and 3. The DMT is the both these.
This order has been passed by
DMT, who is also the chairman of
this order, the impugned order dated 25/11/2024 has been passed by OP number 2, stating that since the petitioner did not submit the document within 3 days as stipulated by this court in its order dated 28/10/2024, the representation of the petitioner with regard to grant of NOC is devoid of merit for consideration for the academic session 2024-25. The petitioner was also advised in the said impugned order to apply a phrase for the next advertisement when it will be published. Next. It is the consistent case of the petitioner that the documents with regard to all the required documents have already been supplied earlier before OP number 2.
The date 30th May 2024.
That is on 30th May 2024.
And they have admitted in para 7 of the counter.
Which has been admitted, which was admitted in the counter affidavit.
In this counter also. This case also they have.
In the counter filed by OP number 2 in the earlier writ petition.
As well as in this writ.
As well as
in this writ.
The counter filed in present writ petition also. OP number Mr. Manti is unable to dispute such contention made on behalf of the petitioner regarding submission of all required documents prior to
the order of this court dated 28 October 2024, passed in WPC number 18624 of 2024. Stop. And on the other hand, it is found admitted on the part of OP number 2 as stated in their counter, that the petitioner has already submitted all requisite documents before OP number 2. Stop. Therefore, according to the order of the as per the purport of the order of this court dated 28 October 2024, the petitioner is not required to submit further documents, and it was incumbent upon OP number 2 to inspect petitioner's institution within a week from the said date of order. But OP number 2 has rejected the prayer of the petitioner institution on the ground that she has failed to submit the document within 3 days as per stipulation given by this court in its order dated 28/10/2024. Stop. Such approach on the part of OP number 2 is seen illegal and misconception. It's seen as a misconception, since it is the admitted case of the parties that the documents have already been submitted by the petitioner earlier. Therefore, the duty is casted upon OP number 2 to have inspection of the institution in terms of order of this court dated 28 October 2024. Stop. Thus, no option is left on the part of OP number 2 than to inspect in compliance to the direction of this court dated 10/2024. Accordingly, we set aside the impugned order dated 25/11/2024 of 2024 under Annexure 6 and direct OP number 2 to take steps to complete the inspection of petitioner institution in accordance with law for consideration of its case for grant of NOC / renewal of NOC.
Grant of NOC.
For grant of NOC.
As for the documents submitted.
In accordance with law. In accordance with comma, within a period of 2 weeks from today.
Item 47.
47, Your Lordship, I may seek a week's time. Need further instructions, though the counter has been filed against some further instructions. Your Lordship.
This particular years.
It's a 3-year contract, but 1 year has already because
No, we are putting to next week.
The housing and catering services.
Yes.
The tender process.
Ms. Patnaik.
You have find a counter, what more? What do you mean?
From the counter, Your Lordship, I have not filed the counter from the counter. I need.
counter has almost admitted our case.
No, Your Lordship.
So why you want? You
For
want
the
for
clar-
preparation, take a time for a week and extend.
For further clarifications of 1 or 2.
What clarification? After the
From the
affidavit
officers
filed,
concerned, Your Lordship, I should be able to submit your lordship.
Fortnightland is it's some more time to get further instruction. List on 21st April.
Item 48.
Mr. Nanda for senior counsel for the petition.
Item number 48.
There are two connecting with retribution method. Sub-item method, who is the first data application filed by the petitioner method. Regarding the method, to exempt the
the other side. In the first writ petition and for the opposite party. In the second writ petition and the petition, both the writ petition arise out of one common. Therefore, both the writ petitions are tagged.
You are for the TPCO,
Yes.
electrical
I'm for the
department.
discount license.
You are
I'm an electricity licensing, supply license.
the method petition.
And with this, there is another person. 48, you have got.
48.
Oh, so that was a Mahalakshmi.
Mahalakshmi
This is the
Mahalakshmi case file. Mahalakshmi is the owner of
proprietor or proprietress.
Yes,
What?
proprietress of Mahalakshmi stone grocery.
Yes.
What
do you say?
Let's say, in so far as WPC 2428 is concerned.
This is your appeal.
This is my writ
This
petition.
is your writ petition. Yes,
But,
but-
my first month, I have initially filed a writ application.
Oh,
Let's
your
take it.
one is a 24 and his is 25.
Yes, ma'am.
Correct. So
After
your
my
one is
lord,
first.
Yes, yes. Here in this case, my lord, I am the proprietor of the grocery.
So it's a demand against the demand or?
No, my lord. Here is the case, my lord, they have, after closure of the, my lord, grocery unit, they demanded the closure period for the closure period, my lord. I am ready to deposit whatever amount till I have.
Against the order of the ombudsman.
Order of the ombudsman.
And ombudsman against, I have challenged against the, my lord, president, my lord, OP number 4, president grievance redressal forum, as well as the partial, my lord, exemption by the OP number 3, my lord, ombudsman.
Just before my learned. Just before the. Well, before my learned
Here
seniors.
in this case, my lord.
My learned seniors.
So now what we are proposing it will take time.
Yes, ma'am.
It is 30.
One more solution is, in my writ petition, notices were issued, if my learned senior for the appearing for the first time. if he does-
Appear. He has not appeared in your.
Yes, my lord. Both arising out of.
He has appeared, na?
No, that's what I'm saying is, it is, if he doesn't wish to file a counter in the writ petition.
Counter against
the
the order of the-
ombudsman order, it can be resolved.
The subsidiary proceedings.
Yes.
Counter.
And both are arising out of one common order.
24th April. 24th April.
For hearing item 50.
Area maintenance.
No, man. Highly only pendant.
No.
They have stated, man. Apart.
Area maintenance, including
man.
it.
No, nothing. There is no can see the pair, man. What they have stated.
All right.
Stated the hearing.
Mr. R. Behra, Land Council for the wife respondent is directed to come up with calculation regarding area maintenance on the next date, list on 21st April. You pay in the meantime, you pay.
Because of the no any order.
No.
So
you cannot.
No, they have, there is no error. There is not an area minor. They have stated during the pendency of the appeal before this honorable court, they all.
We have also said such other or further order or order says.
I